Today's event, International Tax Cooperation and Competition, a Reset. Today we're going to be joined by an impressive group of experts who are going to discuss where international tax may be headed. So this morning we're going to have three panels. And then after that, we're honored to be joined by two congressmen who have worked on international tax, Congressman Ron Estes and Congressman Schneider. And finally, Professor Michael Gretz will provide his thoughts on the future of cooperation and competition. Before beginning, however, I just want to say thank you to my co-hosts who helped put this together, Mindy Herzfeld, Will Morris, and Nate Carden, for all the work they did. I also like to thank our sponsors who helped make this possible, Skadden, tax analysts in the University of Florida Levin's College of Law. And I also like to thank my RA, Ali, for his work putting this together. Now I'm going to hand it over to my co-host, Mindy, who will set the stage.
Thank you, Kyle. I'm not going to put my tea here. So thanks, everyone, for coming. I would like to just spend a couple of minutes talking about how this came about and what we're trying to accomplish here. So we started, Will Morris and I started thinking about doing something that thinks about global tax governance more broadly back a couple of years ago already. And what came out of that was a global tax governance workshop that was held in Oxford in the fall of 2023, which was interdisciplinary to see what can the tax world be learning from other legal models. How could they be relevant to the thinking about global tax governance? We had insights from global trade, financial regulation, environmental law, IP, and national security. Really, what we wanted to do was think about global tax governance from the ground up, take a broader view, step outside the pillars in the OECD versus UN debate. Thinking about what's the role of international tax organizations here, what should their goals be, what should the objectives of reform be, should we be thinking about improved standard setting processes, rulemaking, dispute resolution, or something more limited. Also, what grants an international tax organization or international organizations more broadly legitimacy? How should we be thinking about implementing that legitimacy? What makes an international organization inclusive? Is inclusivity a goal in and of itself here? So after we did that workshop in Oxford in 2023, we did a broader symposium where we did a call for papers last September. Also at Oxford, with some really great presentations from academics. But we thought it was really important to bring this conversation to DC to have a more US-centric discussion about what should the goals of US participation in multilateral tax negotiations be. We're not really looking to debate Pillar 1 and Pillar 2, retaliatory taxes. Instead, we really want to take a step back and think about, given the very severe challenges being experienced by the global tax agreements that both the US and other countries have spent a lot of time negotiating over the past several years, maybe we should be thinking about a reset in how the US approaches multilateral tax negotiations. And as someone said to me this morning, it's probably not the last reset here. What is or should be the US perspective as it enters into these negotiations? How do we think about domestic goals, US domestic goals, versus more international goals as it proceeds with international tax negotiations in a multilateral framework? How should the US be thinking about the role of international organizations here? How should it be deciding which organizations it wants to engage with? Are the existing organizations fit for purpose? What should the US perspective be in terms of the legitimacy of competition versus the importance of coordination? whose point of view matters most? How do we think about the need for revenue versus the competitiveness of multinationals? We're excited that we're hearing from both Republicans and Democrats on these topics, and especially honored that my former professor, Michael Gretz, will be here with some thoughts on how to move forward. And then finally, thanks to AEI and to Kyle for hosting us, and to our sponsors, Skadden Tax Analysts and UF Law. With that, Will Morris moderating the first session.
Thank you very much, Mindy, and welcome everybody. I was recalling to Michael as we walked into the building today that the last time I came here was to hear a speech by Pierre Moscovici, who I think was then the EU tax commissioner, who told us, I think probably for the first time that I'd heard it, that retaining earnings was an unacceptable form of tax planning. So that sort of is the environment in which we found ourselves then, and the past 10 years have seen quite a change in that. Just to add a point to what Mindy said, and I'm going to be slightly sharper about this than she was, gentle. But as we talked about this, as we've gone through the process of the past 10 years, one of the questions which has struck me more and more is this a case of just bad policy choices? Or actually is there something systemically wrong with the way that we arrive at international tax agreements? And without coming down on one side or the other, Mindy and I thought that it was worthwhile exploring the second of those. Are there systemic issues with the international tax policy making framework which ensure that whatever the good input is, the output is not going to work? And that was part of what we looked at Oxford, and one of the reasons for pulling in folks from other disciplines as well. What do they do in the trade space, for example? What do they do in the customs space? You know, all of other organizations with different methods of arriving at rules, different ways of voting, different groupings therein. So that was part of the framework for this originally back in 23, looked at further in 2024, although United Airlines did conspire to prevent both Mindy and I from actually making that meeting, which was something of a shame. And also bringing it to DC, where obviously we thought it would have a different flavor. We didn't, when we were planning this, realize quite how different a flavor it was going to have. But this is nevertheless a good time to sit down here and to consider some of the things that we're talking about this morning. And particularly with these first two panels, but also obviously with the two congressmen that we'll hear from, and from Michael. We'll get a number of perspectives on, particularly from a US point of view, but looking into this international space. And so, the first two panels are reconsidering US goals in international taxation, and then international organizations and the future of tax cooperation, again, obviously, from a US point of view. When it comes to US goals in international taxation, some people will say, do we have any? Others will say, do they ever stay the same for more than a short period of time? A short period of time can be 4 years sometimes, or it can be much shorter than that. So what are they? Is there any consistency between them, or is there a golden thread that runs there? Is it, I go back a long way. I was in the Treasury in the 90s. I know there are people in the room who were there before that. But back in those days, we talked in terms of capital import neutrality and capital export neutrality. Does anybody think about that anymore? Do we think about this in different ways? Is this, the multilateralism, the ascendant multilateralism that we saw for 10 years, was that truly a US goal? Or was that simply a means to achieving things in the US that people wanted to do? Again, we can discuss that. But we thought we'd do this panel in a relatively straightforward way, but then sort of with a bit of a twist, so past, present, and future. And each of our three panelists is going to address one aspect of that, but only for a short period of time, and then have an interactive conversation. But if at any point the audience wants to intercede, this will be a much more interesting event for that. Again, as we were discussing about this, I said, I get still plenty of invitations to come to these things. I say, if it's going to be 3 speeches, the answer is no. So this is not going to be 3 speeches. Questions will make that even livelier.
And we know there's no shortage of people in this room with strong opinions on these
Indeed,
topics.
that's right. The audience was not curated, but it curated itself. So anyway, so the first of these is US international tax goals, to the extent we can discern them, prior to January the 20th. And Michael is going to, Michael obviously with his experience at Treasury in the Biden administration, is going to lead this off. And I think, Michael, you said you were going to talk about 2 stints of Treasury experience. You're going to talk about 2 things. So you're going to talk both about FATCA and about BBB, as opposed to OBBB, and do something of a compare and contrast with that. So do you want to sort of kick this off, and then we'll...
Sure. First, I want to pick up a little bit on your comment about, is there a golden thread through US goals with respect to multilateralism? And I think, first of all, one question is, whose goals count? I can only really speak from my perspective at Treasury, and I would say that for Treasury across most administrations, probably all administrations, the goals of multilateral tax cooperation really have focused on avoiding double tax and protecting the US fisc. Now, the context for that has always been different, and that's why I wanted to talk a little bit about the 2 different stints that I had at Treasury. So the first one was FATCA, right? And in FATCA, Congress passed a statute that put financial institutions in a situation in which they had conflicting legal obligations. And at Treasury, we were really concerned about the potential impact on the US markets coming out of that. And the only real solution was to get other countries to change their laws. And so we worked at Treasury with the OECD to come up with a multilateral solution there. And thankfully, pretty much every other country had the same concerns about tax evasion that the US did. And so we were able to develop a system, the CRS, that is different, a little bit different than FATCA, but it did work as a side-by-side system. And without the OECD, without multilateral cooperation, that just would not have been possible. It would not have been possible to implement FATCA. Now, you might say, well, fine, we shouldn't have implemented FATCA, but that was the statute that Congress passed, and that was our job to get that implemented. Pillar 2 went differently. Now, in some ways, it started the same way, right? You had GILTI passed in TCJA, and the first Trump administration saying, okay, well, maybe we can let other countries develop a global minimum tax as something that they want, as long as GILTI is sort of treated as being qualified under that system. But then we had the presidential campaign, right, the Biden presidential campaign, with a promise to raise more revenue from corporations, including by strengthening GILTI. And that really changed the dynamic of the Pillar 2 negotiations, because the thought was that if that happened in the US without a robust Pillar 2, that would put US multinationals at a competitive disadvantage. And I think that was fairly widely shared in the administration, that viewpoint. You also had the administration thinking that it was in the national interest, right, to show the US was still committed to international economic cooperation. And for political reasons, trade was largely off the table to do that. And so the administration embraced Pillar 2 as a way to show the US was still committed to international economic cooperation. And at the time, you may think that this was, in hindsight, a terrible judgment, and maybe it was, but we really believed that Congress was going to enact Build Back Better. And so Pillar 2 was a really important part of making sure that US multinationals were not in a competitive disadvantage. That obviously, Congress didn't implement Build Back Better, and that created a lot of tension in the US and ultimately in the rest of the world. The sort of obvious takeaway I think, from those two experiences. And I think this actually has played out since the 1960s when the OECD was founded, is that it tends to work best at the OECD when Congress has implemented policy and then Treasury exports that to the rest of the world through the OECD. That is getting harder to do, though. We're just in a different world than we were, 60, 70 years ago, in terms of U.S. Power, in terms of other countries believing that the international tax system is generally fair. I'd say most countries don't believe that anymore, and that makes it just a lot harder to get things done the way that we used to do things.
So I'm going to ask Nate and Mindy in a moment what they think about this, but I'm just going to throw something on this. Part of the fun of this job is to be slightly inflammatory. When I was at Treasury back in the 90s, through no little irony, I was the one person who never got sent to the OECD. However, I did, everybody else came back and told me what they did. And there was clearly an element of the way Treasury operated. I mean, you said this works best when the Congress speaks, the US then takes ideas to the OECD and implements them there. There has always been a strain in Treasury thinking that if we can't get something here, then let's go to the OECD, get them to adopt it, and then bring it back here. So with that, I'm going to ask Nate and Mindy how they'd like to respond to any thoughts they have on what you said.
It's an interesting thing because I guess when I look at Pillar 2, right, there are some differences between Pillar 2 and the GILTI system or whatever we're now calling the GILTI system. But fundamentally, isn't that what we did? Right? We create a worldwide system with a foreign tax credit, and then the rest of the world, we push the rest of the world, in effect, with rules that look an awful lot like we wrote them, to adopt a worldwide tax system with a foreign tax credit. So there's a lot of, and we'll sort of get to the post-January 20th world here in a minute, but just when I step back and look at it as kind of a practitioner dealing with all this stuff, I feel like the differences are kind of around the edges. I mean, didn't we win exactly that battle with GILTI and Pillar 2?
Yeah, I think sort of to your point, it was always going to be a side-by-side system, right? President Biden never proposed to implement Pillar 2. It was always going to be a side-by-side system, and so you're right. At some level, it's just sort of negotiating about which tweaks.
So my biggest takeaway from the past several years is that using international organization to try and get Congress to do something is a spectacularly bad idea.
That's a lesson which has to be learned and relearned, unfortunately. So let me tease out another aspect of this, which is that one of the, I'll put this again more mildly this time, one of the concerns that people have, particularly around Pillar 2, is the impact that it's had particularly on tax treaties. And as many of you will know, the UTPR case in Belgium has just been elevated to the European Court on its sort of compatibility with EU law. There are other concerns about whether it contravenes particular tax treaties. There is a provision which I think is outrageous, which essentially says if you assert your rights under an international investment agreement, then you're not going to get another country can immediately tax that under the UTPR. You think, wow, we are telling people to ignore their international agreements. What is the US policy essentially in allowing the degradation of tax treaties? Let's put aside for a second the difficulty of getting them ratified, which is consented to, which is a slightly different one. But I mean, is there a policy there, or was that just an unhappy byproduct of the way things worked out?
Oh, no, at least in the administrations that I was part of, there was no question that we were trying to support and strengthen our treaties. And I do think that the fact that Treasury has not been able to get treaties consented to for the past 15 years, really, does really influence how things have played out. But I think the result that you see over the past 15 years is other countries just ignoring their treaty obligations, or trying to skirt them, right, with the DPT, with DSTs, with what Australia is doing with royalties. It's not an isolated phenomenon here, and certainly as part of Pillar 2, the intent was not to have a rule that undermines treaty obligations.
I mean, isn't it fair to say, and again, I don't speak for the administration, the current administration. I'm not part of the current administration. I'm just a guy sitting in front of an AEI sign, right? It is fundamentally, I think, to me, and I've thought this since UTPR came out, like, it's not something that's designed to work. It wasn't designed to put pressure on tax treaties, investment treaties, or anything else. It was designed to create a rule where if you were a participating country, you were a chump if you didn't either have a QDMTT or an IIR. It's always struck me as a kind of mutually assured destruction. So is the problem here not so much that folks have walked away from tax treaties or there's pressure on tax treaties as it is that this is just an outcome that doesn't appear to have been seriously considered, and now we find ourselves in it?
Yeah, yes, I think that is right. I do think that it is a provision that, like proposed Section 899, was never intended to actually raise revenue.
It seems to me fundamentally different from saying one or two countries have enacted a diverted profits tax or taking a position that's not an outlier on treatment of royalties than to say the OECD has opted into a standard that it expects all other countries to follow that is inconsistent with bilateral treaties. There seems like saying lots of countries are ignoring treaties seems to me fundamentally different from saying we should all adopt a UTPR, while recognizing that that's not consistent with treaties.
So let me ask one more question about pre-January 20th US tax policy. And this, you talked about FATCA, so this is sort of in the same time range, a little after. When we came to the beginning of the BEPS project, what people are now calling BEPS 1.0, what exactly was US tax policy in doing that? I mean, I heard you say that, sort of international comity, which is always good. And, don't get me wrong, as I'm going to get to this before Nate does, as Mr. 9811, I understand the attractions of being the world's policeman. But what was it that we saw in BEPS 1.0 that was going to be advantageous for the US as opposed to advantageous for pretty much everybody else in the room?
I actually can't.
That's not a personal question.
Yeah,
just to be clear.
No, I actually can't speak to that. I was on the other side during that because I was at the OECD. You hear different stories from different people about how the BEPS project came to be. The way I understood it before I left Treasury was that other countries were pushing for more expansive changes, right? And this was a way to cabin in what other countries were going to do unilaterally with the DPT, with it, potentially setting a precedent for countries ignoring their treaty obligations. And this was a way to get everybody on the same page, recognizing that there were some instabilities in the international tax system, and make it about stateless income, disappearing income, rather than a reallocation of taxing rights, which is what a lot of countries wanted to do.
Mm-hmm. We got to that later. Do you have any thoughts on that?
Well, you stole my 9811.
Yeah, I got.
Well done. But yeah, I mean, look, I think, and this will sort of get to the comments about post-January 20th. I feel like there's been a 20-year trend line as a result of kind of a globalization of the economy that has created a lot of political pressure on both sides where there's just skepticism toward the basic concept of taxation based on factors of production. And so when you think about the BEPS project, when you think about trade, when you think about the project that, known as Pillar 1, when you think about Pillar 2, there's this effort on the part of political actors across the board to identify more inelastic bases for taxation, and they're just having a very hard time doing it.
Right. Good. Okay. So I think we're. I have many more pointed questions I could ask on pre-January 20th, but that's not what we're here to talk about, really. So let's move to January the 20th. So midday we get a new president. Not very long after that, we get a series of executive orders which come out, which appear to reframe, shall we say, U.S. international tax goals. So tell us a bit about that. And actually, is this the rupture that it appears to be, or is my golden thread, is it still there?
I don't think so, right? I mean, when I look at the totality of what has happened, right, and I try to piece out sort of the rhetoric side of this from the actual policy statement and policy action side of this, it really just feels to me like a continuation of a trend line that we're all going to have to confront in the first place, right? I mean, we don't have a sort of sliding doors version of this where we also get to see the version of the movie where there's a Harris administration and what they do. But the reality of the situation is that if you look at where the US was, if you look at where the OECD was, right, we had the sort of guilty pushdown rule, we had the UP safe harbor, all of this was coming to an end. And so we're eventually going to have to confront the differences between the US international tax system and Pillar 2, and there are a lot of them. The Pillar 2 system is built on somewhat of a different theory. It's very financial accounts driven for reasons that are not immediately obvious to me, but it's there. And the US system, right, and most countries were also putting that system in place essentially de novo. They didn't have systems that look like this. We have an international tax system that is woven into the DNA of the code. And so it was just unrealistic, in my view, to imagine that we're going to rip out all of that architecture and replace it with something that looked like Pillar 2, which meant, as Michael just said, side by side was inevitable. And UTPR ultimately was the thing that was going to make side by side unsustainable. And I guess from my perspective, maybe they did so in a somewhat more direct way. But I think the administration basically came out and said, look, we need to solve this problem, and this is how we're going to do it. And it appears, at least based on the pronouncements and such, that they found a fairly stable compromise solution. I will say the one thing that you alluded to, Will, earlier, and Michael, you did as well, that I do think is more material of a change is the perspective on the use of trade as a lever. So I think just observing it from the outside, I think the administration is much more willing to use trade as a lever, which then means that a lot of these other things, like 899, are probably going to be less critical. But beyond that, I guess I'm just not convinced that it's that big of a difference, or certainly not as big of a difference as sort of the tax community likes to make it out to be.
So let me just ask you one follow-up on that, and then open it up to.
Can I also
yeah,
disagree with me?
So on that it's not much of a difference in policy terms, maybe. But what does it say about the US's approach to multilateralism and the value or lack of value of multilateralism?
I guess when I look at it, right, I view the US as having this consistent thread that Michael was referring to of we do it, Treasury writes it, we export it. And in a lot of ways, I think what the US is doing now is, again, maybe a little bit more belligerent in tone, but entirely consistent with that trend line.
I'm not sure that's been true since the early 2000s, but Mindy.
So I really do see it as a fundamental shift and consistent with positions the administration is asserting in other areas to say we will put U.S. interests first and foremost in negotiating in a multilateral context. And maybe Michael will say, but that was always the
Every
case.
administration does
Right.
that.
I don't think there's an administration out there that's saying we put America's interests second.
But I again, like Nate, I just sit here observing, and I wasn't hearing it as clearly. Now maybe Michael will say, well, you weren't in the room, and so that was clear. That was for sure what every U.S. negotiator was asserting, but.
How about, I mean, just to give an example that sort of drives the way I'm thinking about this, right? again, we get the perspective of sitting on the outside, right? But like, I look at something like the foreign tax credit regs, right? Issued under one administration, then, in proposed form, then, finalized by another administration, right? Fundamentally, that was not about the spirit of international cooperation. That was about, we don't like your taxes and we want to collect them for ourselves instead. So I guess I just don't see the giant difference in ultimate policy approach, recognizing there's absolutely been a change in tone.
I know, but let me come back on that one as well, because I mean, one of the arguments about the foreign tax credit regs was that essentially everybody else was taxing the US stuff, and the US was paying for it via credits. Yeah. Right. So again, there were puts and takes there, and that actually went on for a fairly long time. So again, why did the US not push back on that? Okay, so I think that I think there are clearly arguments that there is some consistency, although I would argue it's probably more consistent with the pressures that were applied by Barbara Angus in the early 2000s than most people since then. And that there have appeared to be times when the US has said, I mean, when I sort of half joked about how we, Treasury used to think about the OECD as a place to get things done so we could bring them home, that, it's there, we can't change it now. And there did seem to be an element of, this is somewhat beyond our control. And, the sort of the famous G20 ratchet, that every time you went to a G20 meeting, you got a new communique which said something new and we can't go back. That does not seem to be the way that this administration views things.
What do you think, maybe to push back on that a little bit, what would the alternative universe have looked like where we were confronting the situation we were confronting now, which is, I believe, a sort of profoundly unrealistic expectation that the US would adopt Pillar 2 root and branch, right? Or, would otherwise do tweaking around the edges, right? I mean, maybe a Harris administration and a different Congress would have gone with, the country by country tested unit approach. But beyond that, how would it have really looked different other than tone? Because these problems got pushed for a couple of years with the various temporary safe harbors, but they were coming. So I guess I have a hard time myself when imagining that the world has changed so fundamentally since January 20th. I don't know what the other world would have looked like.
Well, again, sorry, I should really stop talking, but this is one of the points, but I'm not going to. So, one of the points there is, at the UPE level, at the parent entity level, sure, that was always a huge problem, and that was going to have to be solved. At the subsidiary level, that again has been a change since January the 20th, to focus on that, and now the side-by-side, which goes all the way up and down the chain. Previously, there was a lot of focus on how do we get US domestic income out of this, much less focus on the subs. Anyway, Mindy, Michael.
I think that's a tweak at the edges, I think.
Quite a big one.
Yeah.
But the flip side, I think Nate's point is, would we have had that G7 agreement in a different administration? And then a variation on that is, okay, but is the G7 agreement really going to produce anything meaningfully different than just sitting at the negotiating table would?
Well,
is that just a question of whether the belligerents worked?
I think on timing, it probably did. Right, I don't think we would have seen that kind of statement as early, but I think ultimately that was where things were going.
Okay, so let me drag this back from the details a little and sort of take it back up a level. So, we're talking about post-January US international tax goals. Are those, putting aside the implementation of the G7 agreement, which obviously is a fairly big thing to get done, is there continuing US multilateralism moving on from January 20th?
Again, I sit on the outside, right? But I read articles about ongoing engagement in Cape Town, and people are still going to the meetings, people are still talking, and so I guess I strongly suspect that the U.S. will continue to be engaged. Again, maybe with more of a stick in the carrot and stick balance, But fundamentally, I think it's inevitable that we're going to be engaged because the multinational community is going to insist on it, and folks at Treasury and Congress will insist that U.S. interests get protected. And fundamentally, the only way that works is if folks are not subject to double tax or other kinds of novel taxes. So I think so.
Yeah, I agree with that. I mean, I think everybody agrees that tax certainty and stability and avoiding double taxation is in the best interest of U.S. multinationals. Nobody disagrees on that. And the only way you can do that is through multilateral cooperation. Like, if countries just act unilaterally, you are going to have multiple taxation of the same profits. I think the debate is really about whether you believe we can go back to pre-2010 international tax system, or whether you think that we're going to have to find some other international tax consensus. I happen to be in the latter camp. I think that, as I said before, a lot of countries don't believe that the existing system is fair, and they're going to keep messing with it, for lack of a better term, until we come up with a new international tax consensus.
I totally agree with that. I mean, if you look at the BEPS project, it was, remember what the title of the report was, right? Aligning transfer pricing outcomes with value creation. And it took folks, I don't know, 2-3 years to figure out, yeah, we don't actually want to do that, sorry. So ultimately, I think it goes back to a little bit of what I was saying before. I think there's this intermediate to long-term kind of political trend of dissatisfaction with taxation based on factors of production because they're too elastic in this world. When I think about, Will, the comment that you made originally about capital import and capital export neutrality, I guess part of the question is, what does a world of either of those look like when you have, U.S. multinationals that are presumably engaged in capital export, but more than half of their shareholder base is either tax exempt or foreign? Right. Is that capital import or capital export? I just think in the world that we sit in, trying to import those kinds of concepts into international tax doesn't work. And so rolling the clock back, I don't think it's going to happen either.
Okay, so I'm going to have one more chew on this post-January 20th bone, and then we'll move on to what the US's tax policy should be, or international tax goals should be. And that's this, which is, and we've sort of mentioned this before. I mean, so this is a room, I think, largely, maybe entirely full of tax people, and we've been used to having our own conversation, and quite exciting. OECD, things move along. Tax is the center of the world. I do not believe that for this administration, tax is the center of the world. I think trade is the center of the world, and therefore, does that mean that tax is simply a tool in the trade toolbox? And does that mean that tax actually is going to be treated differently under this administration?
I guess I wonder whether tax has ever occupied that level of centrality. I think
in our minds it has.
Yeah, that's true, right? But if you look at sort of if you look at the history of Subpart F and our policies back in the Kennedy administration, and the various subsections that were implemented, you see a whole lot that looks like it is about communists and Fidel. And so I'm not sure that it's ever been that.
And Peggy Musgrave.
Exactly. And I'm not sure. So I guess trade is now a significant issue because of the political consequences of the deindustrialization of the U.S. economy. But I just think that's the thing now. I'm not sure I see it as that different than it used to be.
Mindy, Michael?
I mean, trade and tax have always been really closely intertwined. We ignored we forgot about tariffs as a tax for over 50 years, but this is a reminder that it is part of trade, and tariffs are part of trade negotiations, and tariffs are taxes, and
yeah.
Yeah, I would say just as a subjective experience, like from my first stint in Treasury through my second, it does feel like tax is going from having its own real sphere of influence and getting to deal with tax issues in the Office of Tax Policy to being much more political and cross-administration. I don't know if earlier was was a very special time, or whether it was more of a continuation of prior periods. But it does seem like it is becoming more political.
The ghost of Stanley Surrey is fading. Okay, so Mindy, what should be the US's international tax goals?
Yeah, so I put some thought into this question because I didn't have ready answers. What should the U.S. Goals be? And I start with, well, what are goals in domestic tax policy? Those are two main ones: revenue collection and minimizing and friction caused to business and individuals to maximize productivity and economic growth when collecting taxes to support the state. And then we've got a whole bunch of secondary goals that creep more and more into our tax rules: redistribution, progressivity, administrability, right? We always want our taxes to be easily administrable. Fairness, relating to timing and realization questions. Incentives to encourage desirable social behavior, or penalties to discourage undesirable behavior. All of those are in our code. So then the question becomes, how well do these goals translate in the international area? And there, the overarching revenue goal remains, with the additional need to protect the U.S. tax base from migrating overseas. So we see both of those in our international tax rules. Minimizing friction on business translates to a more nationalist goal of ensuring competitiveness of U.S. businesses. And then there's a big question, which I think we've seen inherent in a lot of the discussions, but how do we think about progressivity in the international context? Should tax rules play a role in redistribution across nations? And is there a role for global justice in international tax? Those, I think, are big questions that people have strongly different views on. And then administrability, of course, becomes an even greater concern when we need to think about rules that cross borders. Incentives, how do we protect U.S. goals when we enact domestic incentives while ensure the competitiveness of U.S. businesses? How do we ensure the attractiveness of the U.S. as a location for investment and for residents? And then we throw in a bunch of additional considerations here as well. Resolving cross-border tax disputes, obviously not an issue in domestic tax context. How do we protect U.S. persons from unscrupulous tax authorities in other countries? How do we maintain the connection between domestic political objectives, legislators' point of view, and international negotiators? I think the tension there is something that's been evident. And how do we make sure that whatever is agreed to in the international, in the multilateral setting, is actually implementable within our existing, and not just the U.S., but within existing political system? And then there's a question, what should not be on this list? And I'd put harmonization high up on there. And then I have a question for myself. How well were these goals expressed in recent negotiations? And in deference to Michael, I'll just leave that as an open question.
So Michael, Nate, do you want to pick up any of those? Or ask Mindy a question? Which is your favorite?
Yeah, that's a lot of goals. Pick three.
Well, yeah, I guess I come back to the sort of the golden thread, right? I do believe it's important for the U.S. To try and avoid double tax. I do think that it's important to try and provide tax certainty and stability for U.S. businesses. I think that makes us all better off. I think to Nate's point, the world has been struggling to find a better base, a more inelastic base on which to impose tax. I sometimes get accused of confusing is with ought, but I think that the trend is clearly toward more source country taxation, more market access taxes like tariffs. And that seems to be the direction of travel, and I think we would be better served to try and find a new international tax consensus as quickly as we can.
I guess I left consensus off in my goals.
Yeah, I completely agree with that. sort of view of the trend line, right? And I guess I would also say that part of our goal, and maybe this was lurking, Mindy, in the things you were saying, but part of our goal should also be to figure out who is best institutionally competent to help drive this consensus. One of the things that I think is different about the Pillar 2 project than others, and I think we've seen this through round after round of administrative guidance, is that I think the OECD does wonderful thinking on tax policy. There's the guidelines I think are useful. Trying to act as a regulator, which has really been the exercise under Pillar 2, I think is asking too much. And so I think one of the goals should be to figure out which international institutions, if any, are the ones that are actually well suited to do that. And if the answer is, well, no, tax systems are different enough that we should actually leave that to regulatory authorities in individual countries, then we actually, OECD and others step back and do that.
Yeah, so we will move on to international organizations in the next panel. But actually, I want to pick up that last point, because a lot of what Mindy says and a lot of what we've been talking about assumes a frame which does actually involve international organizations. And it involves a frame which over the past 10 years has assumed greater and greater cooperation, more perfect union, if you will, in a slightly different context. And I think, one question that I keep coming back to, and some of you will recall, I had my hopefully once-in-a-lifetime experience of appearing before the Senate Finance Committee 2 years ago. And one of the things that I talked about there was the need to...
You got a lot of time ahead.
Yeah, I hope not. To pull back from sort of maximalist multilateralism, if you will, to something which, for want of a better term, I called interoperability, which is the point at which tax systems have to interact. You provide mechanisms at those points, which is sort of what tax treaties are meant to do, to prevent that friction, but you do not go for something which is essentially a worldwide set of rules. And, were those the US goals? Has the administration changed that? Or are we just, is the multilateral ship changed a few degrees its course, but continues onwards?
I mean, ultimately, I feel like that is the essence of side-by-side, right? The essence of side-by-side is, we will cooperate where interoperability is required, but that we think it's unrealistic to have a worldwide set of rules. I guess, back to the prior discussion, I just think that was inevitable. So maybe I was just too much of a multilateral skeptic in the first place, but I don't feel like it's a change.
Mindy, Michael?
I guess with Nate, I was a multilateral skeptic, but I did feel that there was a push for a maximalist position. And just because I'm a multilateral skeptic, that doesn't mean that others in a position of greater ability to steer the ship we're pursuing that more maximalist goal. And I do think that I guess our reset is, I thought there was a need for a reset, and I think it is on its way.
I think there were definitely people who were pushing for maximalist multilateralism. I'm not sure they were in U.S. Treasury, though. So, the Treasury view was always that side-by-side was going to be the way it was. And so, certainly you look at the BEPS project, you look at Pillar 1, Pillar 2, there is a flavor of maximalism there. But I don't know that was really driven by the U.S.
Yeah, it turns out. Yeah, go on.
Can I make a point on the I think when I think of like the maximalist OECD international negotiations and the EU exercise or project of more maximalist harmonization within the EU, I think perhaps those two have gotten conflated, maybe not purposely, but some of the...
Or maybe purposely.
So I think teasing those apart is or recognizing that those two instincts may have been running side by side is useful.
Well, there could have been a couple of overlapping countries in those two, in that Venn diagram. I was strictly told to make sure that I allowed time for questions from the audience. I told you at the beginning that I invited those. I simply cannot believe that what has been said over the past 50 minutes has not provoked some thoughts or hopefully even reactions from some of you. So questions, thoughts? You can ask questions which are in fact statements. That's fine, that's totally acceptable these days. Any thoughts on this? Yeah. There's a mic coming. And if you could say your name as well.
Dave on Spock, no affiliation. I was bringing this up. I wasn't sure if it's related to the topic or not. But if I understood, if a high net worth individual who's American wants to leave the United States for a lower tax regime or country, another country, they supposedly have to pay some sort of severance fee to the U.S. government to do that. And I'm trying to find out if you've heard of that, and I'm trying to find out if you know if they refuse to pay that fee, what would be the repercussions? Thanks.
Well, I'm going to speak from ancient history. When I was at Treasury, which is beginning to become a tiresome phrase, isn't it? One of my colleagues was responsible, I think, in the 97 legislation, maybe it was 98 legislation, for the stuff about expatriation, essentially, which put this 10-year look back effectively on people who were renouncing US citizenship to leave the US. So those rules have been in place now for almost 30 years. So I can see Josh at the back.
So I had the misfortune of writing what became 877 Cap A, which does impose a mark-to-market regime for individuals with a net worth in excess of $1 million. And so that is the exit tax that is paid upon expatriation.
Yep.
And that is the only system now in place. We phased out the 10-year rule.
Good. Yeah, $1 million doesn't buy you what it used to either.
But I think that question illustrates that tension that a lot of what we've been talking about is trying to deal with. Like, how do you, in a world where not just capital is a lot more global and business supply chains are much more global, but people are much more mobile, how do you police domestic tax systems to ensure the tax base? And this is, I guess, the OECD's big new project, global mobility, but it's one that every country has to be concerned about.
You're right. We tend to think of human beings as relatively inelastic, but there's increasing human location elasticity too. So.
All right, I can ask a question. Okay, this is for Michael. So you had mentioned on FATCA, Congress passes a law and then Treasury implements it. It sounded like in the case of Build Back Better, you said you were assuming Congress would pass it. So I guess what I heard was Treasury kind of getting ahead of its skis on legislation. I guess. But on the other hand, you've got an administration, maybe there's a point of view you're representing. I guess, could you talk about the tension between what you're expecting in legislation and then representing the point of view of an administration?
Yeah, so I'd say that definitely the administration, right, per its campaign promises, thought that Build Back Better, the strengthening GILTI, was a good thing to do. Right, and so the administration was pushing in that direction. I think there was also a view that even with existing GILTI, it made sense for the rest of the world to have a Pillar 2, right? For U.S. multinationals not to be the only ones that faced a global minimum tax. I'd say both of those things drove the administration's position on Pillar 2. I do think the contrast that I was trying to make was, as you say, right, the difference between acting after Congress has passed something and acting before Congress has passed something. I didn't think that makes a big difference in the outcomes.
I think that's right. Yeah, Paul.
So, not surprisingly, one of the things that I would like to hear you talk about is what may be the next interoperability problem that Treasury has to deal with, which is trying to impose withholding taxes on services, either in the guise of their being called royalties, like Australia, or just by imposing them. We had the G24 statement last week when they proposed that everybody should have a withholding tax or a net income tax in the destination jurisdiction by services. We were talking about the intersection with trade. I mean, in the United States, trade is less than 30% of our GDP, and globally it's less than 40% of GDP. The services and royalties are the rest. So it seems to me that's a big issue that's coming up. What I learned from what you said is that it's not going to be something that we deal with or is dealt with multinationally until there's major double taxation by having maybe a proliferation of these withholding taxes. But what do you think?
Well, I mean, obviously, one thing that happened post-January 20th was we walked out of the UN negotiations, and Louisa next to you knows that quite painfully. And, you know, that to me does bespeak a slightly different attitude to multilateralism and to that. What it does mean also is that however, that process carries on without the US being there. That is one of the contexts in which that's being spoken about. Now, you can have different views on the UN, and we'll talk about this more in the next panel, so I'm not going to get into that too much. But you know, my guess would be that at least if you asked most people above, you know, sort of the attorney advisor level, they would say, well, you know, we've proved so far that, you know, the trade stuff can help us with this. We'll look at you know, using the stick rather than the carrot. I think that probably in the long term is a little optimistic, but equally, you know, there are schools of thought which I think probably correctly say if you continue to use withholding to that large an extent, you are going to cut down on trade as well. So maybe the economic impacts will have some effect, but I don't know, Michael, others.
Yeah, I tend to agree with that, actually. I mean, I think there are a few options for dealing with it, right? One is bilateral tax treaties. That seems pretty unlikely in the U.S. in the short term to get protection for U.S. multinationals. You could engage in the UN negotiations and try to influence that. That seems fairly useless to me, given the decision-making process there. So I think we're going to see double taxation, to your point, totally uneconomic taxation in some cases, and ultimately the discipline on countries' tax policy is foreign direct investment, and the impact that their tax policies have on that.
I think, like, I see three conflicting, but one is double taxation. Two is what will the U.S. do with the foreign tax credit regs, which is a unilateral, it's not something subject to multilateral negotiation. Three is second, competitiveness of U.S. businesses, and then the third one is that how do we think about approaching this issue and working with other countries on it? Because I think that's a long-term trend, both in terms of what Nate keeps talking about, moving away from factors of production. And so how can we help develop a system where we move towards a new type of regime that also works with U.S. interests?
The last word.
One of the things that I think the administration understands more clearly, or at least has helped me to understand more clearly in its actions, whether they understand it or not, is that trade, VAT, other consumption taxes, and these kinds of withholding taxes are inextricably connected, right? They're all talking about fundamentally taxation on market access, and I think that the administration is absolutely going to have to confront that. I think the world's going to have to confront that.
Great. Well, I'm going to keep to time. So if you want to ask more questions, we have a 15-minute coffee break, and you can go out and eat the delicious croissants that Nate paid for out of his own pocket. So please join me in thanking the panel for a great session. Great. Okay, well, I don't want to discourage people from eating up Nate's croissants, so I'm not going to call people out when they come in late. But thank you for coming back. You may be wondering why I'm sitting here, and it turns out that the first prize in the AEI sweepstakes was to chair one panel, and the second prize was to chair two. So there we go. Anyway, I'm looking forward to this one as well. This is obviously on a slightly different topic, but a continuation of the same in many ways. And what we're talking about here is international organizations and the future of tax cooperation. So again, I get to give some introductory remarks, slightly different from the first set, but probably heading in the same direction, which is that, as many of you know, I was chair of what used to be called the BAC Tax Committee, and then because I was too short, they turned it into the Business at OECD Tax Committee for 10 years. And the month in which I was appointed was the month in which the then UK Chancellor of the Exchequer, the then German Finance Minister, and then French Finance Minister, wrote a letter to the G20 saying, we need to get a handle on this tax stuff. This is not going well. Folks are avoiding, a common pairing of the terms, all sorts of things, and we need to get this started. And that became essentially, from that point at the end of 2012, the beginning of BEPS 1.0. And the OECD, for reasons those of you who know the OECD well are completely obvious, jumped all over that with the G20 mandate. And I talked a little about the famous G20 ratchet, which for 10 years provided excellent momentum for the onward march of multilateralism. You would go to a G20 summit, which happened roughly once every 6 months. You'd get a statement. The statement would incrementally advance or increase, or you pick your favorite word, multilateralism. And then that would be taken home to everybody. Said, look, the G20's agreed to this. We can't go back on that, so we need to move forward instead. And for quite a long time, that worked pretty well. The process in BEPS 1.0 was relatively restricted. It was OECD members and the G20. But at a meeting in 2015 in Addis Ababa, Funding for Development, probably FFD3 back then, there was a bit of a come to Jesus moment with the developing countries and the NGOs for that matter. And one of the outcomes of that, not that they would put it quite this way, was the inclusive framework. And so we go into BEPS 2.0 in a slightly different position. Also in BEPS 1.0, what the US negotiated was that if we don't like it, we can stand aside. They felt that hadn't worked out quite so well. So going into BEPS 2.0, it was everybody has to agree to this, i.e. there's consensus, and if we don't have consensus, then we don't get to where we need to be. Nothing happens. The G20 ratchet was part of the consensus building process, and we arrive at the point where we are today. Obviously, for at least up until probably about a year ago, you pick your date, the OECD was, in the international tax space, supremely the organization that people only ever talked about. There are others which are also there and have been for a while, and indeed, as the UN folks would remind us, preceded the OECD, but rather gave up on that stuff after the Second World War, allowing what was then, I think, the OCSE, which eventually became the OECD, to pick up the mantle of tax treaties and international tax. But those aren't the only organizations in this space. I think one is allowed to call, at least in this context, the EU, the European Union, an international organization, more correctly, a regional organization, but one nevertheless, which firstly has relatively large aspirations, and secondly, with 400 million odd people, and even now, a fair amount of economic heft, the ability to impose itself on the international tax scene. But not only that, also the IMF has dipped its toe in the water, sometimes beneficially, sometimes in its views on tax treaties. One might think slightly differently about that. And even the World Bank, with things like the medium-term financial strategy and suggestions, plans around the need for a minimum level of tax to GDP to sustain a state, has also had a role to play in that, and obviously in development economics more generally. So this is not an uncrowded area, despite the fact that the OECD has shone. But you know, if you're the number one, then people will occasionally seek to supplant that. And we now find ourselves in an era where perhaps the OECD is not supreme as it once was. And obviously we have the UN working on the International Tax Convention, and we have the EU thinking about taxation. Although, given the events of the last couple of weeks in Europe, one might question exactly how together Europe is on some of these issues, and not just around Pillar 2. So the question that we sort of will try to address here and try to answer is around international organizations and the future of tax cooperation. Obviously, this will have a US twist to it, but Louisa will help us rise out of our parochialism a little bit, maybe. Again, for want of a better heuristic, I thought again we'd look at this in terms of past, present, and future. So the past, a short history of the tax international organizations, to the extent I haven't already given it, and therefore taken this away from Adam. Adam, I think, is going to talk, at least open this conversation up as to the past, with particularly with a focus on the OECD, what went right, and even perhaps what went wrong. Adam.
Well, thank you. It is a great framework for thinking about, and I'll focus on the OECD as the sort of big player in the room, at least historically. As you noted, founded in 1961 in the aftermath of World War II, after the Marshall Plan, and it came to being with this idea that commercial conflict could lead to kinetic conflict. That if we can harmonize, lower taxes, reduce trade barriers, we can forestall the next world war. And so with this mandate, the OECD turned to not just lowering taxes on international capital flows and trade, but focused most specifically on double taxation, on multiple countries claiming taxing rights to the same income. And it was in this spirit of ending conflict over taxing rights that fed into this broader goal that the organization was originally set up for. This led them to putting together the Model Convention on Income and Capital, which we're all familiar with. And this is a bilateral framework for countries to come to bilateral tax treaties. It sets up common language, shared goals, but doesn't at least initially say this is where you have to end up. This is providing a one-size-fits-all sort of end state regime for everyone. It sets up a framework for countries to get there on a bilateral basis. I think that ultimately the success of the OECD and this system, this bilateral system that was set up, led to or contributed to the rise of tax competition, which is as over the last several decades, we've seen corporate income tax, headline corporate tax rates fall from 40, 50% to 20%. This reduction in the taxation of international capital investment has been a tremendous boon for economic growth, for flourishing in countries across the OECD and across the world, has actually led to tax revenue going up in most countries as a share of GDP around the world. And it's this, I like to think of it as the OECD was a victim of its own success. That having solved or close to solved the problem of double taxation, unleashed this tremendous benefit of international tax competition. As all good bureaucracies do, they have to find something else to do. And so they came up, or they facilitated the promotion of this new boogeyman. Instead of going after double taxation, they're now going after double non-taxation, or as it became known, profit shifting. And it's this move, which is a 180-degree turn from their initial mandate, one of lowering taxes, one of simplifying and coordinating tax systems on a bilateral basis, to one that requires which is trying to raise taxes and requires a more complicated, more intrusive, and more one-size-fits-all multilateral framework that we ultimately see in the progeny of the inclusive framework. out of these goals, it started small. It started with bulk automatic information exchange, treaties, and snowballed into where we all are today, Pillar 1, Pillar 2. And I'll leave with just sort of one full circle comment. I know we're going to get into Pillar 1 and Pillar 2 a little bit more, but I think there's an irony to this sort of arc of the OECD in that it started trying to reduce double taxation, coordinate tax systems, lower tax rates, and now in its quest to go after profit shifting, to increase taxes on international investment, it has now unleashed what looks like a new round of double taxation in the proliferation of in trying to rewrite what the tax base looks like. It has opened the door for an unstable and more uncertain tax future, one that undermines all of the progress it's made since the 1960s and leads us to sort of the uncertainty of today that requires multiple panels to unpack.
Thank you very much, Adam. So a relatively middle-of-the-road point of view there. So Peter, Louisa, thoughts on that?
Yeah, let me just make one comment. It's important, I think, to recognize that for all of its strengths, all of its weaknesses, the OECD is the locus of most of the tax expertise in the non-governmental organization sector that works on these issues. Its staff and its inputs dwarf the other groups, whether you're speaking of the UN or the other groups that Louisa will talk about later. So in talking about appropriate roles for the organizations, one thing that lurks in the background is that an awful lot of the expertise and just legwork resides at the OECD.
Yes, maybe just like building up on the past. So as I represent the International Chamber of Commerce, we are founded in 1919, and we were the one that asked the League of Nations to produce a report, the famous Four Economists report, that led then to the first model on double tax treaty. Now, I know recent literature has also indicated that we were responsible for the OECD taking over that role. Now, I look at the documents and I see it a bit different. I feel the reason why we ask again to look at the issue of double taxation after World War II was just the fact that it wasn't addressed well enough, and it was still representing a barrier to trade and investment. So from a business perspective, I don't think we really took a stand ever on which is the best institution, but we just always highlighted the really important issue of solving double taxation. That remains the priority. And indeed, the OECD did an excellent work in producing the model. Later on, there was another model produced by the UN Tax Committee of Experts for the developing countries. And we have always been supportive of a model that addresses double taxation. Now, I think the expansion of mandate and topics is something that didn't affect only the OECD, because if we look also at the UN Tax Committee of Experts, again, an expert body that was created for working on the model tax treaty for developing countries, the subcommittees that work under that committee have expanded enormously. So now you don't have just a committee or subcommittee working on that. You have a subcommittee on indirect taxation, another one on health taxes, extractives. So the risk of expansion has been affecting not only the OECD. On Peter's point on the expertise, yeah, I think that's very good, an important point to keep remember, because the tax system is indeed complicated. We all know about it. And then when we try to look for any type of solution or work, we need to have the experts, and that is an organization that has a lot of that.
So let me follow up a little. I'm determined to stay in the past just for a little while longer. So we think about tax treaties, which obviously was, started in the 1920s. We hear this thing about, century old, doesn't work, wrong ideas, all the rest of that stuff. But actually tax treaties, to Adam's point, were a relatively successful way of interoperability, whatever you want to call it, resolving friction, preventing double taxation. And they have come under criticism, and not just in this country, not just in the Senate for sort of the information stuff, but much more fundamentally that these actually are, tax treaties reflect an imbalance in power between rich countries, poor countries, residence countries, source countries, whatever you want to call it, terms which are becoming less precise with every passing year. But what do we think about that? I mean, was that a success of international organizations, or actually was that a failure of international organizations?
It was a huge success. And I think a big shout out goes to the United Nations. When they were doing their work on the UN model, they did not, just for whims, make differences between the UN model and the OECD, which must have been a temptation. Instead, they used the same numbering system to the maximum extent possible. They use exactly the same language. They pick up the commentary. I think, and I'll use this word later in our discussion, humility. I think the UN showed wonderfully valuable humility in preparing their tax treaty. There are differences. They reflect, as you said, Will, source basis taxation as a higher priority. But I think it's tremendous that the UN followed the OECD to the extent that it could. And goodness knows, when you sit down to negotiate a tax treaty, the fact that even if they are fundamentally a UN model country and an OECD model country, an enormous amount of agreement is available just on day one.
Yeah, fully subscribe to that. I think the fact that there is some parallelism between the two models is essential, and it's a very good tool. And I hear the dissatisfaction of developing countries now, especially in the context of the UN, but tax treaties are still the best tool to provide certainty between the different countries and the taxpayer that is going to invest there. And so one of the draft issues notes that we saw published recently in relation to the UN Convention process, there was the indication that tax treaties are barriers to taxation. And we really made clear in our submission that tax treaties are a very good tool for providing a good environment for tax certainty, trade, business, and investment. So it's a pity to see that there is dissatisfaction with the instrument itself, but agree that looking at the past, the UN did a great job in trying to find a model that could work for developing countries, but was not too distant from the OECD one.
So let me ask a question which is prompted in part by the question that Paul asked, which is about withholding taxes and the rise in those. Originally in tax treaties, there was a provision for withholding taxes. They were kept to a reasonable level. But obviously one of the things that we've seen over the past 20 or 30 years is a reduction in many treaties to zero withholding. And again, is that a success of international organizations, or is that a failure of international organizations? That does perhaps seem to come back to bite us.
I'd say it's a success that has turned into a failure. It was a success in that it reduced double taxation. The lower the withholding taxes, the less double tax you're going to have. What we have now is a pendulum that has swung much more towards source basis taxation, or a desire or a perception that there needs to be more source basis taxation. And so having treated withholding taxes as an ill, we are now in a position where just necessarily we're going to need to have more withholding taxes to satisfy really a global desire for more source basis taxation. And what's important to note, and I'm sure everyone in this room is well aware of this, the U.S. is the absolute best place to be inbound investment. We don't tax foreign investment into the U.S. Our withholding taxes are zero or low. Generally speaking, our PE threshold is high, and if the world is going to move towards more source basis taxation, and if the U.S. needs more revenue, one of the things we're going to have to confront is whether our rules on foreign inbound investment to the U.S. strike the right balance.
I think that it was a success, and to the extent that we're on this pendulum, the onus is on explaining why lowering taxes across the board is a good thing, and we should not be in the business of finding new ways to extract revenue out of the most mobile factors of production around the world, to the point of of domestic investment. I think it's clear that when countries try to go after investment, you get less of it. And if they want to shoot themselves in the foot, you can. But international organizations that have done decades of research showing that corporate income taxes are the least efficient way to raise revenue, they're the most economically destructive, should be the championing, should be out in the forefront of ensuring that these systems are always pulling taxes back rather than adding new layers of taxation to the system.
Right. Okay, so I'm going to come back to gross basis taxes later on. But Peter, let's move to the present. And you've already used the word humility, so I'm going to allow you to expand on that. But where are we now?
Well, look, let me start by saying I'm a huge fan of both the OECD and the UN. I've been a consultant at the UN and some of its capacity building. I appreciate what they're doing. When I was at Treasury before Will, I was the US representative to Working Party 1, which is the tax treaty group during the period just before and just after the Tax Reform Act of '86. Paul and Michael and maybe nobody else remembers that. But I spent 4 years at the OECD in Working Party 1 being beat up to a pulp, coming out bruised every time, as the rest of the world told us that we were undermining treaties because we had just passed this legislation that included treaty overrides. So I appreciate and agree with the comments in the previous panel that in many cases the US takes issues to the OECD hoping the world will adopt them, but it goes the other way as well. The OECD was extremely upset with our '86 Act. I think the key for both the UN and the OECD going forward is simply to back down and have a little more humility. I think they do a terrific job of identifying good ideas and fleshing out those good ideas. But I think to try to seek perfection, and that's what I see in Pillar 2, just doesn't work. And so whether we call it a side-by-side, and that's one way to look at it, I'd rather reframe that. I'd rather simply say the OECD picked up on the US model of global minimum tax and then said, hey, do this the best way you can, whatever way you want to go, and allow countries to fit their system to achieve that goal. And if we aren't all identical, then that's fine with me. I don't think we need to be perfectly in line with every country. And let me use an example of what I think humility can achieve. And I've used these examples before, so my apologies for people who've heard it, but it's bank secrecy and corporate bribery. In the 70s, the US was scandalized by some corporate bribery situations. And the US said corporate bribery doesn't work. And it took really 30 years to persuade through the OECD, through other groups, that Germans should not be allowed a deduction for corporate bribes. But it was achieved. And at the end of the day, the whole world now agrees that you don't bribe. Similarly with bank secrecy. In the 90s, and then much more aggressively in the 2000s, the US said, look, bank secrecy doesn't work. And there were some countries, prominent countries, Switzerland among them, but others as well, saying, oh yeah, it works. Come look at our banks. But over time, the world came to realize that bank secrecy was not an appropriate international business approach. So did those take time? They absolutely took time. I'm astonished at how quickly a global minimum tax has taken root. I think we declare victory. I think we say we've illustrated the importance of it. And then if we find in 5 years that there are a few countries that just haven't done anything, we use naming and shaming and point out what they haven't done and work on them individually in the same way we did with corporate bribery and we did with bank secrecy. So I believe in the UN, I believe in the OECD, and I think they simply need to take a dose of humility, take their victories where they can get them, and be willing to take victories over 20 years, not over 3 years. Sovereignty matters. And it seems to me that with a little more humility, these organizations will achieve a lot, and yet will not impinge on sovereignty, which gets hackles up, and will give them a long runway. I'm a strong believer that good ideas win at the end of the day. And so if you can identify good ideas, you can study them to death, and share them and discuss them, I think you can achieve a great deal. But I would seek good enough results and not perfect results.
As all of you know, Peter is not only a humble guy, but a nice guy as well. So Adam, let me ask you a question, which I'm going to sort of say what Peter didn't quite say, which is that tax harmonization is overreaching for international organizations. Any thoughts on that?
So yes, I think is the answer. But I think that this framing is really interesting in relation to Michael's comments on the earlier panel, this idea that the US comes to some solution, whether it be ending bank secrecy or implementing FATCA or implementing a international minimum tax, and then uses the OECD to leverage that around the world. And while I think the framing so far has put that often in a positive light, there's a negative to it as well. FATCA is a tremendously burdensome reporting regime that, in my view, should never have gone forward. I think that bank secrecy is ultimately a wonderful thing, and we should be championing financial privacy rather than eroding it. Similarly, international minimum taxes are additional layers of tax on businesses that simply didn't need them in the first place. And so I think there is a perspective in which the US puts bad policy forward and then uses these international organizations to foist it upon the rest of the world in a really destructive way, ultimately. And so there's a tension where I think there are certainly good things that these organizations have done in reducing burdens, bilateral tax treaties being the primary example. But there's many, many examples that we've gone through where they have been sort of net negatives for the global economy.
Lisa?
I think harmonization, as Peter was pointing out, it's difficult to reach, especially if you have to take into account the fact that there are differences in legal systems, constitutional systems, and those are things that we need to take into account. Although for business that operates on a global level, a level of consistency among the different legislation and tax systems is beneficial to the point that decrease the burden of compliance. I'd like to go back to the humility point, though, of Peter, because I think it's a very important one, and just to focus and reiterate a little bit more about the timing and really the necessity to study proposals, do the different economic impact assessment that are needed to make sure that any proposal that is relevant and makes sense in that jurisdiction. This is particularly true if you're looking at countries with lower capacity to do that study on their own. So I think this is, from my side, is more of an invitation to the international organization to really make sure also there is the availability of the data of the effect of any of this proposal for those countries, because that's helpful to take an informed decision, especially when these proposals have been rushed. So I'm referring here more with a practical example that we lately seen with the UN Tax Committee of Experts in Article 12AA, which is on the taxation of cross-border services, which is, I didn't want to spoil back your comeback on the withholding taxes on a gross basis, but that's basically a catch-all provision on that front. And that was adopted by the Committee of Experts in a little bit more than 1 year, without any economic assessment, again, for countries that when they negotiate that provision, they want to negotiate that provision, might want to have a good sense of how that provision might impact them or no. So that's a pity. Sometimes you come up with these flashing ideas, but taking the right time to think about it, thinking through and think what the consequences will be, I think it's really necessary and shouldn't be seen as success just because we pass something in a couple of years, especially if you want to have consensus and get everyone on board.
Will, let me add one thing. let me give two examples of topics that are out there today that I know both the UN and the OECD have on their minds, but where I think there could be enormous value added by the OECD and the UN. The first would be digital services taxes. I know here we hate digital services taxes. We think they're terrible. But in fact, they're going to be digital services taxes. And at some point, the U.S. is going to recognize that it's a fabulous tax because the economic incidence of the digital service tax falls on the foreign customer, not on the U.S. shareholders of these jurisdictions. So someday we'll turn around and we'll say DSTs are fine, but they're not harmonized. Some of you have probably done that. You've looked at the 30 countries that have DSTs or have considered DSTs. They're not harmonized. And if the OECD or the UN could take a study underway to say, if you're going to have a DST, not to push it, but just say, if you're going to have a DST, then these are ways to harmonize the base, the collection mechanism, and all the rest. Compare that to what happened with the VATs in Europe. In the 60s and the 70s and the 80s and continuing into the 2000s, Europe has come up with administrative rules with respect to the VAT that have helped immensely in administration of the VATs. I think the same thing could be done for DSTs. The second topic would be cryptocurrency. It's here, it's global, it's international. How do we think about taxing it? And how do we get our arms around that issue? I know there are people who say you shouldn't tax it at all, you should not even know I have some. I'm really a secret billionaire, but you don't know that, and that's just great. But we're going to tax cryptocurrency, and I think the OECD or the UN would be a terrific forum in which to, again, not force countries to do anything, but to lay down guidelines on how to tax cryptocurrencies. So I see an enormous role for the OECD and the UN in looking at issues like these, coming up with harmonized model rules. I think that would be extremely useful, whether they get adopted and implemented in the short run or whether in the longer term.
Can I just in terms of topics, new topics, I think like one of the topics where we saw value for both organizations to work was the global mobility. I'm just referring to that because Mindy referred to it during the first panel. And so we've seen with our members a lot of questions coming up on temporary teleworkers, so just like for a limited amount of time. And we put forward some proposals both for UN and OECD on a safe harbor, of a 60-day safe harbor, so for a short, limited amount of time. Doesn't create any sort of complication in terms of treaty, and we work together also with BIAC on that for the OECD front. So there are some topics that not necessarily are allocation of taxing rights or Pillar 1 and Pillar 2 that can actually benefit from multilateral organizations looking at that now.
Okay, so I have another question to ask, but I may have to make one point on the incidence of DSTs before we pass on from that, which is the largest companies have that pricing power, to be sure. Many other companies involved in DSTs do not. And then the elasticity is somewhere else. So it's not quite as straightforward as it all gets passed on like a VAT. But okay, so here is the question, which is that in the present, we seem to have moved away with, certainly in the OECD's case, maybe in the UN's case to a certain extent, maybe some of the other international organizations, from organizations which traditionally were thought of as data-driven standard setters, which took their time, which goes to the point you were making, to do whatever it was that they did. Now, not everybody liked a 10-year OECD project. That was not quick enough for some. But we are clearly now in a phase where the international organizations and international tax cooperation are different, where it's more about speed, it is more about coming up with policies quickly, it's more about, to a certain extent, imposing things on people than it is getting them to agree, despite the fact that we use the terms consensus. Do you agree with that? And is that the place that we need to be going forward?
I'm happy to answer, but I'm happy to let Adam or Louise answer.
I do think that is the shift, that we are moving into a world where these organizations are feeling like they need to move quickly, and that is leading to policies that are worse than they were previously, that they're not fully thought out. They're also taking on much more complex projects. So you would think you need more time to figure these things out if you actually want to turn the OECD into a global tax regulator. That should take much longer time than what they previously were attempting to do. And so I think that is one of the sources of tension that we're seeing today.
And Peter, WP1 in the mid-'80s and WP1 now?
Let me bifurcate your question and answer it in two different pieces. Has the world sped up? Absolutely. I mean, everybody here read Blink, and everybody knows their corporation says, move fast, break things. So yes, I think the world has moved faster, and the appetite, the patience for waiting is down. But you said a second point, Will, that I think is in fact the mindset, but is mistaken, and that is to force things on people. Sovereignty matters. Sovereignty really, really matters. I teach at Duke and have primarily international students in one of my classes, the other's mixed. These people are from, developing countries, not often relatively poor countries. They're very smart government tax officials in many cases. That's how they were selected to come to the U.S. for further study. They are proud. They like their country. They're proud of what their country can do. And they don't want people forcing things on them. So they're happy to listen. They're happy to take good ideas. That's what they're here for. They want suggestions. But I think the idea that the OECD or the UN or anybody else can force changes is laughable. We want it. We'd like that. That'd be a great, convenient way, just like parents would like their kids to do everything they tell them. But I just don't think that's realistic. So yes, the world's sped up, but we are not going to force countries to do things. And so let's speed up. Let's offer good ideas. Again, good ideas win.
Hubris. Okay, so that's a nice segue, though, to not hubris. What you would the international organizations is a nice segue to Louisa. So the future. What does the future look like? And I teed you up as talking about the UN, but what some of the other organizations that I didn't talk about were other regional organizations. So there's ATAF, for example, the African Tax Administration Forum. There's PFLAC, which is the Latin American Caribbean one, and then there was FFD, which is Funding for Development, which took place earlier this month in Seville, in Spain. So talk to us a little about what the future might look like, or should look like.
So I can say a little bit of what might look like, should look like. we will see. But indeed, I think like in the last years, we didn't just see like these two organizations, OECD and UN more recently, coming up to the stage when it comes to international tax policy, but also more regional organizations coming together and with different mandate though, and have different results and objectives and priorities in mind. So ATAF brings together tax administration in the African countries, and they've been doing really a lot of work to bring together tax administration across the continent. They provide research, they do guidances for them, but they also take political stances. So they were very instrumental for the work done together with the African Union at UN level to get the resolution that started the UN process. So there we see like a regional organization that provides capacity building, but also like policy suggestions for the region and also like globally. And so this is an important and interesting organization to see now in an international stage. They also, of course, participate in the inclusive framework, bringing their experts, and they act as a bloc, which was indeed envied by other developing regions around the world. Because they were effective, they managed again to get some things passed, whether it was like the global inclusive framework on some details, or whether it was the UN convention that is still now today led by the African countries. Now, following that, we saw other regional organizations coming up more recently. One is PTLAC that you were mentioning. That's the Platform for Taxation in Latin America and the Caribbean. that was initiated with a ministerial meeting in Cartagena back in 2023. And there, it was a bit different in the sense that the platform has also evolved differently. They started as a platform, as a regional organization that was supposed to have sort of more political mandate when it comes to OECD inclusive framework and UN convention. Also because for technical expertise, there is also SIAT, for instance, in the region. But it was very difficult to get Latin American countries with similar position, with sort of agreement on a regional position. There were some countries missing from the start, some countries just observing. So it has evolved into looking more at what are best practices for the region. Focusing on 3 topics. One is progressivity, environmental taxation, and the last one is tax incentives. So we started with, let's come up with, again, like a miraculous new proposals to let's look at what is already existing and can be beneficial to share across the region. They also have meetings before the negotiation session of the UN, just to inform members. And I think that's very important because one thing that lacked, especially at the start of the UN Convention process, was participation by Ministry of Finance. So many developing countries were represented by the Ministry of Foreign Affairs in the missions in New York. And that makes it challenging if the decision is not taken by having a sort of comprehensive sense of where taxation fits into the economic activities, economic ecosystem of one country. So it's important that they create also a bit more of knowledge around the process, because then having people from the Ministry of Finance is really key. On FFD4, just concluding on that, so going back to UN, that's the Financing for Development Conference, and just took place in July, beginning of July in Seville. So that was quite an interesting process. There is, for the outcome document in the negotiation, there is indeed a tax part this time as well. And it's interesting also to see how the focus on priorities have been shifted from topics that are to be addressed in the convention. So for instance, one topic that we invited the UN to consider, but also the Platform for Taxation Latin America, was the formalization of the informal economy, so broadening the tax base. That is now a very long paragraph in FFD4 outcome document, but we didn't see any mention of that in the convention when looking at ways to mobilize domestic resources. So it's also like a little bit of a question mark how the 2 documents, the different process reconciliate as of now. But yes, this is at least like what I see now, and it will be a question also like how these documents, this organization will influence the process going forward.
So Peter or Adam, do you have any thoughts on the future?
I have a question that would love your thoughts on. You listed many of these organizations having goals like environmental taxation and progressivity and adding sort of these new features to the tax base. I'm curious how you see that sort of, in one sense, an expansion of what international tax organizations have done previously, feeding into either success or failure in the future. Is it trying to like add all these new things into the tax discussion, making these conversations more prone to failure, or is there, or do they have to be part of the conversation and we just have to muddle through? How do you sort of see those pieces working together?
Yeah, so I think like, especially when we look at PTLAC, that was the organization that I mentioned as this 3 work stream, their intention was to bring, first of all, those were areas that were identified by Ministry of Finance to be priorities for the region. Initially, there was also a digital taxation one that was carved out from the work streams later on. But in terms of what they were planning to do on those areas, initially, so the first year was really how to come up with new proposal to suggest whether it's the UN or the OECD. So in the UN Convention, in the terms of reference, there is mention of environmental taxation. It's not been picked up as a matter for protocol, for instance, but it was mentioned. And similarly to the OECD, so the idea was to come up with proposal and have those topics be addressed by the international organization. Now, in the second year, there's been a shift because there was some already challenge within the region to find a common proposal that they could bring forward to the international organization. So in that case, they're less successful than ATAF in bringing together the countries to agree on common proposal. So what they started to do in order to work on those topics was to look at what is existing in the region, which countries are doing better than others on those topics, and share those information. I have to say that differently from other organizations, at least from the private sector, they always accept suggestions. They can accept revision on the documents if we have any remarks or comments. Of course, timeline is always a challenge for public consultation. We were all used to OECD 1 month. That's a dream when it comes to those organizations. Sometimes they give you 5 days and you have to mobilize the business community in that region. It's not easy. And then, other cases like the UN, they gave us the documents to read in 3 days, but we will do our best.
2 quick comments. If we're in a betting world, I'm putting my money on the Latin America, South America group. I think we will look back in the future, we'll look back and see the Cartagena 2023 conference as a real watershed. I think that group is going to coalesce and be extremely important going forward, even though today most of us don't pay much attention to it. The second point is I think we do a disservice to ourselves and to the organizations when we write about this as the who's winning. I'm looking at you, Robert, but I'm also looking at Nate and at Josh in your firm write-ups about this stuff. You guys love to talk about who's winning, who's not winning, what's going on. I urge you, and I will be reading to see if my advice is taken by anyone. I urge you to quit talking about who's winning. This is not a competition. It doesn't help anyone to frame this as a who's winning. It's a question of all of us as an international tax community, who's got good ideas, who's putting them forward, and how are they being adopted.
All right. Okay, so we're going to move into Q&A in just a second. Where is Josh? Maybe Josh doesn't want to be asked the cue. But just one sort of final thought on this, which is that, Peter, you were talking about Blink, and we can come up with all sorts of other things. Is there the possibility in this age of shortened attention spans of an international organization which fulfills the purpose of simply maintaining things? Or does it have to be in the nature of an international organization that it tries to do new things the whole time?
I don't think it's necessarily about an international organization. I think it's in the nature of bureaucracies writ large. It's difficult to just do the thing that you were set up to do as soon as you accomplish that task. In my sort of initial remarks, there's always that you have to find the next thing. Otherwise, there's no reason to continue your funding at the level it is and keep all the people working on moving that frontier. And so, unfortunately, I think that's the problem with many of these organizations is they tend to just perpetuate new problems that they need to fix rather than sort of sticking to what their core competencies are.
Peter, Louisa, thoughts on that?
Yes. Oh, Peter, go.
Yeah, here's my dream. If you assume an investment pot earns 4%, I need to find a really rich guy who will put $500 million aside. At 4%, that's $20 million a year. That would buy you, just rough numbers, that would buy you 60 very smart tax professionals who otherwise are going to be teaching at universities or going to work at law firms. You take 60 very smart tax people and draw up an agenda on all of these things, AI, crypto, the role of consumption taxes, on and on and on. And they are nonpartisan. They don't have any authority to push anything out. Can you imagine what that think tank could generate in terms of revenue raising and good ideas and simplification over time? So if you've got some friend with $500 million, it's an incredible investment in the future, not only of tax policy, but of business policy, of the world economy, because I want to hire those 60 kids and get them rolling on good ideas.
And then
As
Congress
I
can...
said, Peter is such a nice guy. We have to ask who guards the guardians, though.
I was going to say, I love this idea, because then Congress can finally get rid of their appropriation for the OECD and the UN, and we can sort of step back from all of this nonsense.
A last thought on this, Louisa, and then we will go to the Q&A.
Yeah, so I won't take more time, but I feel like there is a degree of novelty in everything. I studied in Austria, I'm a Schumpeterian, maybe for some side. But indeed, there is some sort of evolution and novelty, and we have to catch up. There are topics and topics. The one I was referring to was the global mobility. But there are also ways to look at solutions. Sometimes an easy, very practical consulting with business solutions, such as the safe harbors that we suggested, could be a good, again, solution to address a problem without reinventing the wheel, embarking on like very large projects, and that are difficult for everyone. So I'm not saying no to an evolving system, but it has to be well done and well thought through and with research, and with that I'm looking also like at engaging with all stakeholders to make sure that it reflects and it works for the people that then I'll have, and the business that will have to apply.
Great, thank you. So questions, thoughts, statements? Michael.
This is a statement followed by "and what do you think?" question, which I think is the proper form of the question. I just want to point out that Adam emphasized the economic disadvantages of corporate taxes, which are widely agreed. That is, that it's the worst tax, as you put it, economically. But the rest of the sentence for me is, but it's the best tax politically. And so if you look at Biden's efforts in 2022 to tax billionaires and 100 millionaires and so forth with minimum taxes, you know, where he ended up in the IRA was corporate taxes. And so I think that's not unique to the US. I mean, as we see DSTs and other things around the world, taxing corporations, especially somebody else's corporations, but any corporation will do in a pinch, is politically sort of the first moment as politicians act. And so I think that in this conversation, one has to take that into account as to how low we're going to go in this story, although I appreciate Adam's views that, you know, we just ought to get rid of these things. They're just awful. But, you know, as awful as they are, they're here to stay. What do you think?
I'll add one additional thought and then turn it over. I think that is the feature of, that's why we need to preserve tax competition, and the mobility of global investment is what prevents politicians from jacking up rates and extracting revenue from incredibly costly mechanisms like the corporate tax. And so the preserving this framework that we have that has given us the pressure that keeps tax rates low is a tremendous benefit. And to the extent that what the OECD is trying to do is erode that relief valve, is ultimately going to make us all worse off.
So there seems to be an inherent tension between Peter's point of organizations should have more humility and they should stay away from perfection, and Louisa's point of they should be constraining themselves a little, and then Adam's point about, well, they're just bureaucracies, and bureaucracies by their nature will always try to expand their portfolio. They need to justify their existence. Like, those points seem fundamentally at odds, and so how could they possibly be reconciled here? The only way I see is like if the organization gets some kind of external shock, which forces them into a reset, but I'm interested in your perspective.
I think that that's a great observation, and you're right. I think that and maybe I'm being too naive, but the original sort of OECD mandate of eliminating double taxation, putting together a bilateral treaty framework, had consultation and it had humility and it had a narrow focus. And so I guess I'm rarely optimistic, but maybe my optimistic take is that the shock of what the Trump administration is doing and the sort of blowing up the whole Pillar 1, Pillar 2 negotiations and wherever we land after that could be that shock that sort of right sizes these organizations, they get back to basics. But I think it's, we'll see where we end up, but I think you're right that there needs to be something that scales all of this back and gets focused on what actually matters rather than this continual sort of addition of new priorities.
I'm going to answer your question in a slightly different way, although you've heard this before, so apologies to you at least, which is that my feeling is that we've reached a point at which it's becoming relatively obvious that one single international tax organization cannot do everything for everybody. And yet there is pressure, nevertheless, for international tax, I'll loosely use the word cooperation, at least interaction. And therefore, my guess, and it's only a guess, as to what works out over the next several years, well beyond my working career, I hope, is that all of these international organizations continue to exist in one form or other and do something. But we get to a stage where perhaps to provide that interoperability, those international organizations can essentially negotiate with each other. And it's not going to be sort of dualistic between the UN and the OECD. There will be regional organizations, there will be other organizations there, and that we reach a point at which stability, if that's what we all hope for, that stability is provided by those international organizations being able to talk to each other. An imperfect analogy is the USA and the USSR and its groups of companies during the Cold War, which is, there's a standoff, but it's a stable standoff. And I think that with different countries and different economies in different parts of the world, maybe that's where we end up.
30 seconds. Mindy, obviously external shock could be the catalyst for it, but I think leadership matters. I'm a gentle guy. I think the right leader, strong leader, but cooperative leader for organizations can make a huge difference without an external shock.
We've had a couple of strong leaders recently, and let's leave that there. So as you can all tell, actually, I did win the first prize of getting to moderate 2 panels. This has been a huge privilege for me. This has been a great panel. I've really enjoyed this. So please join me in thanking the panel.
Thanks, Adam. Yeah.
Carl, you're next to Kyle. And now I'm on this end.
Whoa, bright lights.
Very
Big
bright
city.
lights. Very. And a big screen.
Sorry,
I
very
hadn't
tall
really
people are in the way now.
expected that.
Right.
It's not
Wharton
something
has
which I have
those.
any familiarity with.
Yeah.
We don't.
Okay.
Good to go? All right.
Uh-huh.
Good. All right, welcome back, everyone. So thought we would change it up a bit. No more Will as the moderator. Also, we will also have we have 4 panelists instead of 3, and I think this panel too will talk a little bit more about policy than the previous 2. So this panel will be on competitiveness, competition, and domestic tax incentives. So from my view, this issue has been pretty central to international tax since I've been in tax policy for over a decade. So when I started, the whole conversation over corporate reform in the United States was about competitiveness, how to reform the tax code or lower the corporate tax rate to become more competitive. I think internationally it's also important. The issues of BEPS, for example, it's, policies like patent boxes were central to that debate and how to structure those. And it's become a big issue for Pillar 2. So the structure of Pillar 2, I think, has a lot of interaction with domestic tax incentives, a lot of interaction with just general concepts of competitiveness. So we are going to be talking about that. So for this panel, I think we're just going to go down the line with some introductory remarks. Everyone will give some thoughts on this issue, and then we'll jump into a moderated discussion where if anyone has comments on what others have said, feel free to jump in. And if at any time in the audience there are questions, jump in. Want this to be as interactive as possible. My goal is to also speak as little as possible. So with that, I will hand it off to Carl, and you can start.
Okay. Well, thank you for having me here today. I wanted to start off by talking a little bit about the notion of competition and just remind folks that, in this discussion around Pillar 2 and whether or not we're going to have more tax or non-tax competition, and just remind people we're going to have competition, right? As long as there are differences between countries, there will be an incentive for those countries to do something to offset those differences. And those differences don't have to be tax differences. I mean, we had an experiment with that as well, with the sort of common consolidated corporate tax base that was not super successful, about trying to eliminate tax differences. I would put a lot of the Pillar 2 effort in that camp, and maybe progress could be made there for those who see that as desirable. But there are going to be non-tax differences that are going to exist, related to things like geography, natural resources, labor force quality, and things that are not going to go away. And as long as those exist, countries are going to, in the competition for capital, which is, the one thing that economists have to offer the world is that, wants are unlimited and resources are limited. And so as long as you're trying to meet unlimited wants with limited resources, you're going to have a competition to allocate those in the best way possible. And so in thinking about what you do with those differences in geography and natural resources and institutions and the workforce, you're going to try to offset that in whatever way you can. And if tax becomes more difficult, you're going to see a movement towards non-tax. And I think in the non-tax and tax space, you can think about, well, which of those forms of competition sort of is more or less desirable? And I think, at least as an initial matter, and what some of the literature has found over the years, is that tax might actually be a preferable space to have competition and incentives than non-tax. And there's at least a few reasons that have been addressed around this. And one relates to sort of the administrative costs. The administrative costs of tax incentives are often front-loaded. They're in the design phase of it mostly, right? So I'm looking at some of my colleagues, former from the Hill, right? Like, you spend a lot of time working with technical staff to make sure the rules are right. And there's a lot of effort that goes into that. And you want, really good thinking that goes on the front end of like, well, what kind of rules are we setting for the terms of competition that are going to play out? And then you have a big reg writing process that happens at the Treasury Department in the United States or other countries in their administrative divisions that tries to figure out how you're going to implement those things. On the non-tax side, a lot of the administrative costs are back-ended. Everybody's got to come in and they have to apply. Right? You have to figure out, do you meet the criteria that we think are necessary for you to get the incentive that we think we're trying to give you? And there can be a lot of friction. Now, there's costs on the part of the taxpayers or market players. They're not always going to be in the tax base in this world, right? And with the side of the government. And it's often the case that people found the administrative costs of doing those non-tax incentives are higher. The criteria may be more specific, there may be more awareness that the resources are in fact limited, right? Because there might be a dollar cap on the appropriation for those incentives as opposed to more unlimited incentives that might be in the tax space. Those are both features and bugs depending on one's perspective on those. But that's a significant difference that might lead you to say, maybe the lower administrative costs that are front-loaded to the process and can not get in the way of the administration that might prefer a tax version of this. The other thing that people talk about is sort of, do you misclassify some incentive as being marginal to a particular investment decision or not? So this is a criticism of things in the tax space, right? That everybody gets an investment credit. It might not be only those who are going to only undertake that incentive because you gave them a credit, right? In an ideal world, everybody would walk in and they'd have a number stamped on the head with the effective tax rate that you could charge them with, where they would still be willing to go through with making an investment, and the government would sit and observe it and say, I see you've got 15% stamped on your head, you're going to pay 15% on this incentive. Where somebody else walks in and they have a 0 on that stamped on their head, well, but your investment returns must be tax-free in order for you to come here, and so we're going to do that for you. And you run the risk in both of those scenarios of misclassifying somebody as being marginal or not. And so we write rules to try to make sure we're only giving you an incremental credit for expanding research, activities, for example, maybe in one version of the credit that exists. But there's going to be misclassification in that space. You also have misclassification in the non-tax space, where market participants have an incentive to represent that they are really marginal investors, and they may not be. And it turns out that that risk is actually, at least some of the literature has found, as large or larger in the non-tax space as it is in the tax space. And so you don't solve that problem by moving to a proliferation of non-tax incentives. And the last thing that sort of is pointed out is sort of a lack of transparency. So I'm from Philadelphia originally, and there was a mayor at the time who used to carry around in his jacket pocket a laminated map of the election results by ward. And when you would come in and you would ask for things from the mayor's office, he'd pull out his little piece of paper and look at the election returns from your ward. And if you were one of those that was very good for him, then you would be more likely to have success in your ask, and if you were from somewhere else, less, right? Everybody knew that, so I suppose there's a level of transparency that's with that, but you can understand that that may not be the case. And never mind whether you're the prime minister's brother, or you're, you have to make a phone call to the county to approve your, permit. It exists at all levels of government, this sort of thing, where a non-tax incentive has more scope for a less transparent administration than a tax rule, where the rules are public, the criteria of the law are public, the regulations are public, and in that context, there may be more transparency about what you get. And so whether there's a preference for sort of non-tax versus tax incentives, I think it's a little less clear. And the last thing I sort of want to touch on is sort of when you think about an economics problem where there's private information, this is a case when some of these other issues might be more important. If I'm a market participant and I know more about what my investment's going to yield than the government does, what's the likelihood of success of my innovation investment in an R&D project, or something like that? The tax incentives might be preferable than the non-tax incentives, where you've got to make a determination on those non-public pieces of information about how good the investment prospect is. And this is something that's sort of particularly important in the innovation space, where you don't have experts on all of those cutting-edge market developments inside the government institutions that have to approve the non-tax incentives. And so I think the tighter you try to constrain those things, which is what we've seen in the effort on the international stage here, you're going to see a proliferation of those types of incentives under those tighter constraints. One of my favorite quotes in this area is that the central element of control is evasion. And so the more that you see, I think, in efforts to try to tamp down, particularly tax competition, the more likely you're going to see expansion in other areas. And with that, I will stop.
So one thing that occurs to me in your argument is it's very different than how what you would hear from tax people with respect to tax expenditures in the United States. So we have more than $1 trillion of tax expenditures. People will call that hidden spending in the tax code, and that would be followed up with an argument that, well, if you want these to be genuine spending, you should just make those spending programs. So is that argument incorrect, or does it just depend? Is there maybe a difference between individual income tax provisions or spending or business tax provisions?
Yeah, I mean, as someone who was at the Joint Committee and worked on the annual tax expenditure publication, I don't know that hidden is the right word that I would use to describe that. I mean, there's a statutory requirement to make a public list of them, not just by the Hill, but also by the executive branch. And so I think people know what they are. I think people may not like them, and that's there are lots of things in there for you not to like. Particularly if you're a fan of an income tax, right? Then you think you should tax income, you should not have exemptions that move you away from that system. So I don't think it's a hiddenness or a lack of transparency that's a problem. I think it's more of, do we decide we want to have these deviations or not? Are those incentives that we want to have? We have incentives for investment, we have incentives for consumption, we have incentives for particular types of consumption, particular types of investment, and those might create all kinds of economic distortions that are, good, bad, or indifferent. Very few of them, I think, probably relate to sort of what economists would call Pigouvian tax kinds of ideas, where you're trying to correct for known externalities that you know the measure of. But I don't think transparency is the problem with them.
Well, I agree with basically everything that Carol says about what we will see if we get if we manage to really tamp down tax competition, is that the competition is just going to shift into other areas, and shifting it into other areas may not be beneficial. But what my comments are going to be directed to is, I don't actually think that Pillar 2 is going to do very much to tamp down on tax competition, because the more you read the details, the more spectacularly ineffective a device it is, which may be traceable back to what's possible through international competition or through international organizations. So for example, one of the things that is allowed by Pillar 2 is intra-country blending of tax regimes and tax amounts. So you can't split your income between low tax Ireland and high tax Germany, but if Germany has a low tax treatment for some types of income and high tax for other types of income, Pillar 2 says that's just fine as long as the blended tax rate is 15%. And what that means is, I think we're going to see more development of special tax regimes like the patent boxes, or I guess it's now the FDDEI in the United States, where countries are going to offer concessionary tax rates that are lower than their normal tax rates for types of income that traditionally had been, shall we say, displaced to tax haven countries. And as a result, there may be less revenue received by tax haven countries. Not all tax haven countries. Ireland, for example, is still projecting that it's going to make more money out of Pillar 2 than pre-Pillar 2. But you're not going to raise as much money, as much extra money through the corporate income tax as you think, because a lot of that income is going to be, or a lot of that tax is going to be lost through the concessionary rates with these dual tax systems. Another problem with Pillar 2 is, again, when you look at it carefully, it actually allows the continuation of a lot of existing tax incentives. Depreciation, accelerated depreciation is one of them, but there's also that substance-based carve-out, so that a lot of companies are going to just, say, oh, a lot of our income isn't subject to the 15% tax because it falls under the substance-based carve-out. But the really bad thing, I think, in the Pillar 2 regime is the treatment of tax credits, right? And this goes back to your transparency point and dishing out money through the tax system as opposed to grants. Under Pillar 2, refundable tax credits are not treated as tax credits. They're treated as the equivalent of government grants, which And what that means is that a taxpayer can claim for Pillar 2 purposes to have paid a tax which they haven't actually paid. You know, they can make $0 in payments to a foreign government and say, oh, gee, I actually paid, you know, $280 to the foreign government, defraying my Pillar 2 obligation, because that $280 was offset by a refundable tax credit. And the supporters of Pillar 2 say, oh, we're not worried about refundable tax credits. We're not worried about refundable tax credits because unlike non-refundable tax credits, legislators really don't really see the amount of these refundable tax credits, and they're just not going to give a lot of these refundable tax credits. And I think that's nonsense for exactly the reasons you were pointing out. We do, at least in the United States, we have tax expenditure budgets. There is every indication that the members of Congress take the numbers that are in the tax expenditure budget seriously. They take them into account for determining the revenue that's raised or the revenue that's not raised, the revenue that's being spent. And that process, by the way, is exactly the same for refundable tax credits as it is for non-refundable tax credits. So to the extent that they think that there's something wrong with non-refundable tax credits, it's a problem with refundable tax credits as well. But the real problem is there's a problem with non-refundable tax credits, refundable tax credits, and government grants. If what you're after is trying to get more money out of corporations in order to spend that money on other things, well, it's not going to happen if there is political support for spending the money on corporations to invest more in whatever country you're dealing with. There's nothing about Pillar 2 that gets rid of economic competition. I don't think it's possible to get rid of economic competition. And as long as there is economic competition, well, you can maybe squeeze, you know, one end of the balloon, and all that happens is the other end of the balloon expands. It's going to come out one way or another.
Thank you. All right. Well, thanks for the invitation. It's a real pleasure to be here. My first job out of law school was working at the International Trade Commission. I worked for two commissioners, both of whom became chairs of the commission, Susan Liebler and Ann Brunsdale. Ann Brunsdale is a name that may be recognized to some here at AEI. She was a long time ago in the 70s, head of publications, and then later became the first editor of the Regulation magazine. As is appropriate for editor of Regulation magazine, she was both a free trader and a free market person. And my work over the last few years has really been sort of focused on the difference really between those two ideas, mostly in the context of the United States domestically and the European Union. Sort of questions about what the Dormant Commerce Clause, an issue that's highly debatable in the US given its atextuality, and the fundamental freedoms in the European treaties where there's really no debate as to the requirement to deal with them. But in both the US and the European Union, there is constant confusion and difficulty in enforcing these provisions. And much of that confusion goes back to a more basic confusion, that between free trade and free markets. And the idea being that free trade, and not just limited to trade in goods, but includes services, investments, et cetera, is really about something like a level playing field, given however you are at home and your ability to enter into the other markets. And the Europeans saw providing this level playing field is critical, frankly, to competing with the United States when they formed the European Union, because they had all kinds of tariffs and non-tariff boundaries, because things tend to slip if the tariffs are out of the way, that created national champions in each of those countries. You've probably seen some of those cars at some point in your history, maybe some years ago, that had to compete with the US companies, which had access essentially to a national market. They sort of took Adam Smith's idea that the division of labor is limited by the extent of the market and said, we need a big market. And so what we need to do is we need to pull down barriers, but not necessarily harmonize our system, but make it possible for EU-wide companies that were successful to sort of dominate the EU and then sort of compete outside. That's different than what we might think of as, for those versed in the old vocabulary of international tax, capital export neutrality, more simply locational neutrality, the idea of locational incentives. The idea being that to eliminate those situations requires harmonization in most cases. But to eliminate or to create a free market, to create a situation of free trade doesn't require that. What it requires is the elimination of tariffs and various non-tariff barriers. And so courts are pretty good at rooting out tariffs and have struggled more with non-tariff barriers. But what they can't do is they cannot essentially harmonize. If they have to harmonize, they're choosing winners versus losers. They're really cutting out sovereignty. And that is something they cannot do. Now, reading the cases, and I've read a lot of those cases, and I know, Michael, you've read a lot of those cases over the years, there's real confusion with the courts over these two concerns, over basically providing a level playing field versus providing a situation that's sort of harmonized where goods, services, businesses don't get attracted, wealthy people don't get attracted to some locations over the other. I think it's important going forward to try not to compromise the idea of the level playing field. The other issue, the question of, in essence, do we allow states to compete? Do we allow states to encourage activities to be brought to their state, and how do we restrict it? That's something that courts can't handle. That has to be handled legislatively within, say, a particular country, in the US with many states, by international cooperation. But the recognition that that's the only way to handle it doesn't mean that all acts are good or necessarily that no acts are good. And that's really where we sort of find ourselves. And I think it's important to recognize as we go through these issues, we're really often focusing on locational issues, and do what we may. Mm-hmm.
Thanks so much for the invitation, Kyle. I think it's important when talking about incentives that anybody in a conversation about incentives is likely bringing a policy baseline in their mind, and that is what does the tax code look normally before you add on incentives. And I think that fundamentally has shaped the way different countries have thought about tax incentives in the domestic context. So if you think that a kind of traditional corporate income tax system is the normal policy, then incentives beyond that are the choices you have to make, and you have to make several different choices along that path. You may make a choice on an expenditure-based tax incentive that says, if you spend this amount of money, then you get this credit that's adjusted for the amount of money that you're spending. or something that's more income-based, like a patent box that says you just get a lower rate on a stream of income, or further down the line, what has already been mentioned here, is sort of a grants-focused incentive where the government's just going to write a check, or you might have a refundable tax credit. But again, in each circumstance, you might have something in the back of your mind that's like normal policy. And I think one of the interesting things that I've seen in the context of the global minimum tax, and certainly with some aspects of the US cross-border rules, is that different countries have very different approaches, or when you try to get countries together to design what that policy baseline is, you're going to have disparate outcomes depending on what you kind of bring to the table. So if you look at the Pillar 2 system, you can look at things that I would say are normal tax policy, but other people would say might be incentives, like accelerated depreciation, and the way Pillar 2 approaches that issue, that approach is generally blessed. Now you need to adjust for the rate. So if you're depreciating gets to 30% corporate tax rate, you have to adjust those things downwards to a 15% rate. But that's still kind of blessed within the framework. Similarly, some in the debate would say generous loss carry forwards, you are an incentive relative to a normal regime that would limit those in some sort of way. I would disagree with that. But again, the Pillar 2 system is relatively generous with respect to these timing elements with accelerated depreciation or loss carry forwards. Where it begins to put a thumb on the scale is when it comes to the different ways you might approach incentives on the expenditure side or the income side or the grants approach. And the kind of traditional tax credits that the US uses for a lot of its business credits are penalized relative to some of the grants or refundable credits, and to a point made earlier, the type of differentiating between types of income within a jurisdiction, there's kind of a thumb on the scale there as well, relative to the approach that the US takes with, prior to a lot of the changes that we've seen in recent years, especially with the new FDDEI approach. But I think one of the things that policymakers need to do now in this framework is think through what sort of decision points they will have to make in the context of whether they're looking over their shoulder when designing domestic tax incentives or not. Because if you're US policymaker and there's this trend now that is leaning towards more domestic manufacturing, do you think about those incentives in the context of this broader debate and what it looks like to have something that might be looked at with a critical eye from your colleagues across the ocean? Or if you're in a developing country context and you're really trying to attract inbound FDI, and whereas previously you might have had incentives designed for particular industries or particular zones within your jurisdiction, how those decisions might be made differently if you're concerned about let's say an EU country utilizing an income inclusion rule to claw back some of those incentives. All of this is very unstable ground right now because it's not clear what the future of this current approach, both with Pillar 2 and with the new side-by-side approach, where that's going to leave some of these incentive conversations. But I will endorse the earlier points that one of the things that is going to be the case is that countries are going to figure out ways to compete. And one of the things that you could do if you're a finance minister and you don't want to worry about the way Pillar 2 or the way the new version of GILTI, we'll just call it that for right now, approaches incentives that you might give away, is, well, maybe we won't deal with corporate tax. Maybe there's some sort of special reduced VAT regime or a payroll tax rebate or some sort of infrastructure pot of money that you pay into, and somehow that infrastructure pot of money, comes back to benefit you and your organization because you might need, an extra power plant here that's conveniently located next to where you're going to be doing your power-heavy manufacturing. And that's where I think a lot of the to the extent that we're on shaky ground in the corporate tax space, and individual jurisdictions are continuing to think of ways to compete for inbound investment and ways to iterate on their tax incentives, it may spill into other areas of tax policy because, to Carl's point earlier, there's an administrative advantage to staying within tax policy rather than just leaning on the general fund and the budget for writing checks or the transparency concerns that come out there.
Thanks, Daniel. So we're going to start with some Q&A. So I actually would also like to open it up. Anyone who has questions, there is a mic going around. But as people are thinking about their questions, I think I'll start with my own and go back way high level here, something that wasn't answered. So we heard that countries are going to compete. We heard why they're going to compete. We heard why Pillar 2 is not going to stop them from competing. But no one really answered the question whether competition between countries with respect to tax policy is good or bad. Is that something that we want? Is that something that we want to discourage? Or is there a line drawing we have to make between good types of competition or bad types of competition? And just open that up to anyone that wants to take that.
I'll jump on that and curious of the other panelists' views. I think it is good because part of what you see when there's projects to harmonize tax rules is you see a limiting of the ideas in the space. So to the extent, and we heard this on an earlier panel, the value of iterating on ideas and people understanding where something new might solve a problem in a different way, once you start trying to mitigate competition through a harmonizing project, you're essentially saying, well, we don't care about future ideas or a lot of existing ideas for managing corporate tax policy. And in fact, to Adam's point early on an earlier panel, maybe we don't need to be investing so much in corporate tax as a policy, but one of the things that is consistent with having a corporate tax is thinking about anti-avoidance strategies. And if all of a sudden everybody just agrees, well, this is the only way we're going to tackle anti-avoidance, then you're immediately limiting the ideas and the innovation that could happen in that space to either solve or choose not to solve that issue.
Well, ideas, innovation, it's also responsive to local differences. It's a big world, and indeed, even within this country, it's a large country, and we have a wide range of at least state tax and city tax differences, and all of that gets sort of, or is at risk of getting thrown out depending upon how much you harmonize. There are, of course, also some externalities and concerns that some industries are more mobile than others. There are situations where countries have monopoly power, certainly over various resources and other things, and so there's some exploitive opportunities as well.
I worry more than a little bit about this being essentially a lawyer's relief act. That Pillar 2 has so many escapes, and there are so many incentives to comply with Pillar 2, because it is going to make multinational industries, enterprises' lives easier. That people are going to spend a lot of time coming up with the best escape for their particular enterprise and lobbying for it, and they're probably going to get it, which is why it will be a lawyer's relief act.
Is that better or worse than a system where there is no Pillar 2 and lawyers are exploiting differences between existing tax systems?
I think it's approximately the same, and that's sort of my problem with Pillar 2. It's being sold as, oh, this is a great advance. It's going to lead to a lot more revenue. It's going to level the playing field, et cetera, et cetera. But actually, I think it's really quite ineffective. Which is sad.
I guess now that I'm at PwC, I should say I hope it's an accountant's relief act as well, not just the lawyers should be left behind.
Absolutely.
But more seriously, I think there are types of competition that at least national governments should have no interest in, right? If you're a national policymaker in the United States, you don't really care whether the new plant ends up in Texas or in New York. Right, like you shouldn't care as a national policy objective. And so when you're thinking about tax policy at the national level, to the extent that there are things in there that encourage that kind of competition, those should probably be eliminated and pulled out so that you're not, as a national policymaker, cared about that level of competition. On the global stage, it's a little trickier because if you believe that one of the reasons competition could be good is because it has everybody compete down to the most efficient level, right? That might actually be different among different countries. And that might mean all of the activity would end up in one place where the most desirable environment existed. And if you care about anything else, non-economic policy, which of course economists, we don't care about non-economic policy, right? But there might be other people in the room other than the economists writing the rules. Then you might need to do something that's different, and there will be competition that the benefits of those areas might be outweighed. I can think of an example in like the national security space. What if China were actually the best country in the world in order to produce all of the intelligence software and hardware for the United States? We probably still wouldn't do that out of national policy concerns. And that might be a good reason, even though it might be better economics, to have no tariff and trade, non-tariff barriers on technology transfers to the Communist Party of China. But for other reasons, we're going to have those. And so I think the competition, good or bad, can't just be looked at in, this is like heresy for an economist, right? Like, we don't actually run the world, and we shouldn't. We should be there and making sure that we're not doing anything unnecessarily, but there might be other policy considerations that override. And in that context, you want to be explicit about what those are, and you want to have economists in the room so they can quantify, well, how much is that going to be worth it to you if you're going to do a non-economic thing, so that you're explicit about those trade-offs.
I want to throw a lawyer word on it briefly, which is if we have rules, especially international rules, how are we going to enforce them? I mean, the EU has state aid, which restricts very much the ability to deal with incentives. They have a whole legislative system. They have a court system designed, and even that struggles to deal with it. What is going to be our international system here, even if we do reach agreement as to how it's going to be enforced, which suggests there's going to be more and more opportunity for leakage.
Yeah. Reminder, any questions out here? Go ahead, Paul. Mike's coming around.
I think some of the proponents of Pillar 2 have tried to oversell it, but I think it's still worthwhile if you limit what you're trying to say it's accomplishing. And that is, to my mind, reducing tax competition based on rates, in other words, based on income, as opposed to tax competition based on spending. There's a huge difference. We learned that in the United States with Section 936, which I helped draft back in the 70s, where we encouraged income in Puerto Rico. We got a lot of income in Puerto Rico. We didn't get a lot of jobs. And that's what's been going on with investment hubs around the world. They've been getting a lot of income. What Pillar 2 can do, if it works as one might hope it will work, is to limit tax competition based on tax rates, so that a company that ends up making $1 billion a year in Ireland doesn't pay $20 million of tax, but pays at today's rates, $125 million of tax. And I seriously doubt Ireland would give them a grant or a refundable credit for $100 million a year every year that they're there. So if you just say what Pillar 2 is trying to do is to limit tax rate competition for income and limit it to expenditures, I really think they made a mistake in Pillar 2 when they drew the line between refundable credits and non-refundable credits. They should have drawn the line between expenditure-based credits and income-based credits, right? Because that's would accomplish the goals that seems to me are worth accomplishing and are realistic to accomplish.
I think one of the issues with that is if you think that people are responsive to rates in different ways, and one of the goals of your tax system then is to equalize sort of the marginal substitution across different types of income, right? Like, I want you to be indifferent whether you do this type of, earn this type of income or this type of activity, and I want to use the rate as a way of adjusting down the tax burden on the most sensitive type of activity, right? The one that's most likely to flee. Then the rate actually is probably the right instrument to use to do that. Now, that's not everything. for sure. And if you've got lots of inframarginal benefits when you lower rates on income, that is not actually sensitive to that. But I think you're giving up potentially a tool that's actually the most efficient way of accomplishing that sort of neutrality principle across different, the responsiveness of different types of activity.
And there is going to be rate competition. It's just that the rate competition is not going to go below this 15% blended rate. And so the rate of tax on some stuff is going to be really low. And the only difference is that the tax that's collected is not going to be collected by traditional tax havens where nothing happens, where there's no high rate income. It's going to be taxed by the higher. Well, that is what gets the low tax
look,
countries
it's not
out.
perfect, but it's getting at something that that came out of the earlier the period of time after 2010 with stateless income and everything, where you were having companies paying a 2% rate on hundreds of millions of dollars a year in various jurisdictions. That's not going to happen anymore.
But of course, we have guilty.
Yeah, right. Of course. And maybe that was enough, but Pillar 2 is just an expansion, as we talked about in the first panel, of guilty. And you can quibble with whether the design should be more like guilty or more like Pillar 2. But all of those efforts are efforts at basically saying, limit your tax competition to spending incentives, whether it's wages, whether it's R&D, whether it's building factories. Don't have them be based on low income tax rates, because then you get these huge rents for the successful companies, right, that they get in low tax jurisdictions, and that causes real political problems as well as lost revenue.
But if you think that the deadweight loss associated with taxation is related to the square of the tax rate, you might not want to be so encouragement of higher rates on all that other income. Right, but if that's the blended rate and you're saying you have to increase the tax rate on the high tax stuff, right, that means you're going to accept a lot more deadweight loss associated with that activity that bears that higher rate. And it doesn't go up linearly, it goes up exponentially.
Right, and I think your point on expenditure-based credits or expenditure-based incentives is the right policy answer, broadly speaking. Like, if most countries could find that solution themselves, we wouldn't have to have Pillar 2, pushing them in that direction. But I think the other element that Carl was just touching on is this kind of divergence that you would end up with. The more you're hollowing out a tax base for a particular type of expenditure or investment, not only does Pillar 2 push rates up to be able to make sure that you have that blended rate at the right level, but you may have some politically acceptable or desirable level of corporate tax revenue that is also going to be pushing in that direction. And that's something that kind of fits into this whole triangulation of incentives versus what Pillar 2 might dictate versus what revenue you might want to generate out of a corporate tax base. Yeah.
Or any tax system. I mean, we've sort of forgotten that the purpose of taxation is to raise revenue for government to spend money. And sort of that ultimately in the long run has to be close to a balance.
Yeah.
Mindy, did you have a question? Oh, okay.
Sorry, this probably won't be as good as your question, but I was going to ask, is there an impact on government structure? And I'm thinking specifically of our legislature. I think many countries have a parliamentary system, prime minister and majority, they agree and they do stuff. We don't necessarily have that because we have the filibuster in the Senate, though an exception we have is reconciliation, which certain criteria are met. So the provision, the new Section 899 cleared a hurdle to needing a simple majority. It had a hurdle ahead of it, but before it got to that, it was pulled because of the G7 agreement. But does the fact that we have need a simple majority in one house of our legislature affect how these things are decided? To what extent is the rest of the world aware of that, and what impact it has on our ability to respond?
Well, it might actually be more granular even than you're making it seem. I mean, if things are paid for through grants. The grants don't necessarily get structured and approved through the same committees in Congress as the tax incentives get paid. And I don't know whether it is harder to, as a political matter, to get a grant approved out of a, the agricultural committee or something, than to get an equivalent dollar amount of a tax credit through joint committee. So that's sort of an unknown. If we start really pushing towards, oh, you can't have any sort of tax credits at all. They're all treated as reductions in tax for Pillar 2 purposes, so they're going to get washed out, which, as I say, is not the current structure of Pillar 2. We might be living in a different world in the United States, or we might not. I don't know, and I don't know that anyone else knows that. I mean, years ago, George Yin wrote a paper about this, like 40 years ago, in which he said there wasn't very much difference in terms of how much scrutiny things got at joint committee versus the underlying legislative committees. But that was a long time ago. I have no idea if it's still relevant or accurate.
I think there's a level at which your analysis is correct, because there's a lot of flexibility for other governments to be able to move things quickly, and we saw this in parallel in the months following, or the months even leading up to the model rules on the global minimum tax, where the Build Back Better struggled to get passed. Model rules come out. A lot of parliaments around the world move quickly to put you had the European Commission put out a directive, which in European Commission timelines was like super fast to be able to get that approved and then parliaments to adjust. Meanwhile, Build Back Better turned into the Inflation Reduction Act, and a lot of the provisions that would have changed GILTI in some ways in the direction of the model rules kind of fell out. So you could say that even in a situation where there was single party control of all three factors, that the U.S. approach to these policies is just different than what we see around the world. But I think additionally, one of the things that's going to be interesting to see is that there has been shift towards adopting the Pillar 2 rules, but I think the dust is nowhere near settled on the direction of travel for kind of policy innovations on incentives. And I think countries are still really trying to figure out like what buttons they want to push. There was a lot of early reporting about some countries in Southeast Asia and the approach they might want to take. So I think it's going to generally be true that some countries are going to be faster tracked than others, but it's not necessarily just a U.S. versus parliamentary systems distinction.
So we talked about looking forward a little bit. Big Beautiful Bill passed that changed GILTI and FDII, renamed them as well. Had the G7 announcement that said nothing really. What should we expect going forward? So a lot of these critiques that we've made of Pillar 2 so far apply to what exists now, but things might change, and how do you think that's going to impact domestic incentives and competition going forward? Anyone can take that.
I'll start. I'll try to be real brief on this. So I think even at this point last year, there was a deal to be had on the distinction for refundable versus non-refundable credits, and I think that deal is still available. The side-by-side approach has introduced new wrinkles in the discussion, and we've seen all the reporting and the efforts to figure out like what this actually means. But I think underlying that, and maybe carried along as part of it, is this fix, I think, to the underlying structure of Pillar 2 that does not actually meet the intent long term of that expenditure versus income distinction. And hopefully there's something that we see come out of this process along with answers on what side by side really looks like and when we can expect that to be working as either the U.S. or the G7 statement, what that actually means. Yeah.
I mean, I think we've had a little bit of a question on sort of, does Europe understand the institutional peculiarities of the United States with respect to the executive versus the legislative branch? I think there is a parallel question there for understanding the EU and what it can do through its directive that maybe it's not as well appreciated on this side of the Atlantic. But I do think the incentive to make sure we get something out of this is very strong in Europe. Yes. And if they can't do it through the directive, they will find a way to do it through administrative guidance or other things that are around to try to get something that works. I think we may not appreciate how difficult that may be for them, but I don't know that we care a whole lot about how difficult it might be for them any more than they cared about how difficult it might be for us to just repeal all of our non-refundable credits and replace them with refundable credits, because that's really simple for Congress to make happen, right? Like, those kinds of issues I think are out there. There will be some desire, because they recognize that competition is ever present, to constrain it in some way that is favorable to them. I suspect that they never started as a way for Europe to actually protect itself against the United States, and the real competition is not among companies, but for really a US versus Europe kind of thing. And so I would be surprised if we end up with a set of rules that doesn't, from that, somehow make Europe look better off at the end of the day, at least in the eyes of the Europeans. Whether they can actually get there or not, I don't know. I don't think the current administration cares two wits about what Europe thinks about them, and as long as the US is out, whatever rules they want to have for themselves and everybody else, I assume that they'll probably be fine with.
I mean, it seems to me that the world is becoming more competitive rather than less competitive, that there is, on all sorts of fronts, much less interested in, let's see if we can come up with a deal that's good for all of us. It's becoming more nationalistic and more interested in seeing what's good just for us. And a lot of it has to do with trade and competition. We're realizing that it's not a great idea for China to make most of our pharmaceuticals, for example. And so there's real interest by every country in onshoring more activity. And I'm not exactly sure how that's all going to fit into the Pillar 2 context, because I think that's going to place much more, there's going to be much more political support for doing things that attract actual business activities to countries. And if that comes in the form of, we can do this by having dual rate systems and refundable tax credits that actually do bring the effective tax rate in terms of out-of-pocket expenditures on operating businesses way down, we're going to do that, Pillar 2 or no Pillar 2.
Yeah, I mean, more emphasis on blocks, I think, internationally. And the GATT story, I think, is one could bring down tariffs, and where does the pressure go? It then goes to non-tariff barriers. Those have proven much more difficult to tame. I think that's sort of part of your Pillar 2 getting around it sort of story. Yes. There's a long history of this, and sometimes it takes really something major. The Depression, World War II, sort of leading to GATT. It was quite an impetus, but boy, it was a hell of a cost.
So I think what I hear you saying collectively, something either like competition is good, or there's an economically efficient role or economic justification for competition. You get to a more efficient result, or competition is inevitable, and so the effort to tamp it down completely is always going to be a failure. But I'm curious on the coordination side, presumably you would all say there is at least some role for coordination in some spaces. And so is there an economically efficient spot for coordination? And how would you develop the formula for that? How could you figure that out from a economic, mathematical, scientific perspective? Or is it just like this, we know this is too much when we see it?
I mean, so, when you have a hammer, everything looks like a nail. So I see all of I view the whole world through that lens, right? That's marginal benefits and marginal costs, right? If there is a benefit to coordination, you need to figure out what those are. And there's going to be some level at which, the more coordination we do, we get more benefits out of coordinating together. But there are costs associated with doing that. And we can't pretend that those are zero. Otherwise, we'll do too much effort into the coordination space at the expense of other things we ought to be doing. And so at some point, what are the costs of those of doing that coordination? Are we giving up too much in terms of the efficient outcome on, that would result from competitive interaction? Are we giving up too much in terms of the marginal improvement in some of these kinds of things, which might be relatively small relative to the cost incurred in doing that, and the costs of instability that we impose on the sector, on the world as a result of that, which reduces, returns everywhere. And what that you would want in order to be able to figure out what that is people figure out, what do we think we can get? What really are the benefits of that? And I think in a lot of economics, we've developed lots of very sophisticated models around this kind of things, and it turns out you don't get much further than if you just take the simpler approach in some of those things. And so sometimes just saying, do we think this is the juice worth the squeeze on that? And I don't know that there's been a strong articulation of what the benefits of coordination in this area actually are, just know what we think we could get. I mean, if we had gone back and thought we're going to do all of this huge rewriting of international tax rules for something like $10 billion a year of revenue, would we have bothered with the project? It's just not, it doesn't seem on a global basis that maybe that was worth it. And maybe we would have worked to see, maybe let's see what BEPS 1.0 would have done first before we launched on 2.0. And I don't know that there's been a lot of inquiry into what the marginal benefits of that level of coordination are.
If I was to characterize two potential areas for benefit, one is process, and the other is a kind of an informational level playing field. So one on the process side, if you have disputes over profit shifting, or double non-taxation type things, or if you have disputes over countries that are grabbing too much of, or a perceived too much of a particular tax base, you need a process for those countries to work things out. And it may not be that just bilateral conversations is going to be the best process. There might be multiple countries that have similar thinkings of how these problems could get worked out, but you probably need somebody who's a referee in the process for working that out. And then the informational approach, one of the things that I think that is missing a lot from the UN conversation, and Louisa referenced this earlier this morning, but the OECD has tried, sometimes not very well, at doing is trying to provide information that all stakeholders could respect about a particular problem or issue. And that's not something that individual countries might have an incentive to provide. So having some entity that is incentivized to provide information that could, in theory, be roughly neutral to the issue, I think both of those are areas where there's some value in coordination.
Great. Well, we are now at noon, so it is lunchtime. So join me in thanking our panelists.
And thank you for setting this up.
Thank you for doing it.
And Congressman Estes will be here to give his address at 12:30. All set? All right, welcome back. So for one of our lunchtime addresses, I'm happy to introduce Representative Ron Estes of Kansas's 4th Congressional District. Prior to being elected to Congress in 2017, Mr. Estes served as the treasurer of Sedgwick County and then as the 39th state treasurer of Kansas. And at the outset of his congressional career, Estes was the only former state treasurer serving in the House, and today I believe is the only former state treasurer on the Ways and Means Committee. Correct me if that's out of date. And as member of Ways and Means, he is assigned to the subcommittee on tax, and he has the distinction of chairing the subcommittee on Social Security. Please join me in giving him a warm welcome.
Well, good afternoon. I guess it's afternoon, right? Is my mic on? All right, good. I've got some notes here that the staff prepared for me, so maybe I'll use some of them, maybe I won't, as we go through this. So that's always the fear, right? When you're up here, or it's always their fear a little bit when I'm up here. It's great to see you, be able to talk about things that are going on in the world, and particularly things that are going on as we relate to tax policy and good economic policy, which drives good economic growth. A lot of you probably heard several of these conversations from me a lot over the last several months as we've gone through this whole process to talk through what we should do from a tax code policy within the United States and what we wanted to do moving forward there. It's great as we're at this point now where we're wanting to focus on how do we make sure that we have good policy that makes good economic growth for companies to do business in America and benefit American workers and American economy, and ultimately raises money for tax revenue to have to fund the government and the activities that we do here as well. And that's kind of been my focus since I've been on Ways and Means now 6 years, and looking at that. I came on shortly after the Tax Cuts and Jobs Act in 2017 was passed into law. That was my first term in Congress, and so the guiding principles, even back then, we're looking at how do we make U.S. more competitive in the activities that we do. And I go back and talk a little bit about 2017 and then translate it to some degree how our efforts with TCJA in 2017 tied in with the efforts in the One Big Beautiful Bill this year, and then how that's also connected to the OECD discussions on Pillar 1 and Pillar 2. I like to go back and do a little bit of review of history when we talk about TCJA, because we think back to 2017, the state of the economy at that point in time was everybody was talking about this new normal, that we should just expect low 1 to 1.5% economic growth. And that should be the standard that we should expect in the United States. The United States had the 4th highest corporate tax rate in the world, and highest of any developed country. And so it was always putting our industry at a competitive disadvantage as we sort through activities. We had stagnant wage growth for 2 or 3 decades. In terms of the average taxpayers, was the mid to high 30s was what the income level was for the individuals across the country. We also had inversions was the topic of the day. Whether you were a Republican president or a Democrat president, it was a problem that you were trying to address where because of our high tax rate, it was profitable for foreign-based businesses to come by a valuable U.S. entity and convert it into headquarters being overseas, and actually partially pay for that through the lower tax savings just by getting out of the U.S. tax burden. And then the other component that doesn't get talked about a lot is the amount of money that was trapped overseas. I mean, literally it was in the $4 to $4.5 trillion where subsidiaries of US-based businesses had operations in foreign countries. And because of the existing tax rate, they paid taxes in that country, the territory where they were operating in, but the U.S. tax code said, well, we want to double dip and tax you to bring that money back. So that money was being left overseas, was actually being invested and helping grow the economies over there, which wasn't what you want from a U.S.-based business or entity. And so those were some of the big issues that we wanted to address with TCJA. It kind of drove a lot of our thought process as we went into that, and what we starting with just driving the corporate tax rate down to 21%. And even at that, we weren't going to be the lowest tax rate. We didn't want that. We're still, by the time you combine the 21% corporate rate with state and local taxes, we're just above the midpoint of OECD countries around the world. But we think that's appropriate. I think we'll still be competitive just because of the innovation with U.S. businesses and the activities that we'll do focusing going forward. And so in addition to the corporate rate, we also wanted to make sure that we looked at how do we incentivize investment in research and development, investment in capital expenditures, investment in our workforce, investment and being able to deduct the interest deductibility used for that investment. And so we structured different provisions around that. Some of those end up being temporary. And so we've had a actually good field experiment the last 8 years where we've seen the results of 2017 going forward to now and saw the economic growth that came out of that. And now we're at the point that where we were working on with the One Big Beautiful Bill to extend those provisions that had been temporary, and in the best case scenario, make as many of them as we could permanent. We also got caught up in a lot of the campaign promises from last election, particularly from the presidential race, and some of the new provisions that came in: no tax on tips, no tax on overtime. No, 88% of the people won't pay tax on their Social Security because of the credits, the enhanced seniors credits they'll get. Those are new items that we hadn't talked about previously. But what we were really wanting to do with the One Big Beautiful Bill is how we make sure that our economy gets back to growth mode and that we continue to have good economic growth and wealth creation for not just businesses but individuals, as well as funding the Treasury. I can go down several instances in the Treasury where we actually have more receipts now than we had on things like royalty tax payments, because we had the incentive for research and development being done in the United States. Companies either brought the research and development back or started it new in the United States, and therefore our royalty income is hundreds of billions of dollars higher than it was. And what we've seen is the CBO, as most of us, Republicans and Democrats, criticize the CBO for their scoring methods. We all think it needs to be changed some. We just haven't got to a point where we agree on what to change it to. But even what we've seen is through 2024, actual revenue was increased over what had been projected prior to TCJA. So even though the discussion that there was going to be a loss to the Treasury with the Tax Cuts and Jobs Act, that did not happen through 2024. And so now as we look forward with OECD or the One Big Beautiful Bill and rolling out those provisions, so many of them that we're able to get permanent to move forward, going to be so beneficial for us in an operations side. I talked about a lot of the domestic value for economic growth and how do we make things happen. Obviously, as part of that, we also need to talk through from an international piece and the issues there. When we were finishing up, again, I go back a little history-wise, when we were finishing up TCJA, part of the last things done were figuring out how do we fit in and address the growing concern about the race to the bottom on global taxation. And obviously there was a concern on everybody's part that you don't necessarily want to lose your business to a company or country that is taxing less just because they're taxing less. But what we did was we implemented within TCJA provisions like GILTI and BEAT in order to help address that, to help offset that temptation that somebody would go look and base their operations somewhere to get advantage just purely for tax purposes. And so at about that same time, there were discussions going on in the world around both from the same concern as well as a concern of raising revenue in individual countries. And so 6 years ago, 7 years ago, so when I got on Ways and Means, one of the first things that got engaged in was talking about digital services taxes, the DSTs. And that was becoming the hot topic at that point in time because multiple countries were promoting this idea of having a digital service tax and looking at it as a way, basically for revenue, was what the driver was. And what I became an advocate for, along with a lot of others, was let's utilize OECD and come up with a consistent approach instead of having a patchwork quilt of different codes and tax systems across the world. And so that was the basis for start the discussion on what ultimately became Pillar 1. About the same time that we finished the TCJA provision, then it also turned in that other countries started talking about how can we address the lower tax rates and making sure that we're actually being fairly competitive in that, which led up into the discussions on Pillar 2. This was kind of starting at the end of the Trump administration, the first Trump administration. The discussion there, as the discussion with Pillar 2 started up, it was more focused on a thought process along the lines of what we'd put into Tax Cuts and Jobs Act in terms of how you look at provisions like GILTI or BEAT or FDII and craft something that works for your respective country, whether you're European-based or Asia or Africa, that actually accomplishes the same goal or a similar goal to help incentivize companies to operate within your country and not look to run to some country that maybe dangles a particular foreign rate, a low rate in front of them. The problem that happened after we had change of administration and the Biden administration was moving into the discussion was the discussion on Pillar 1 kind of just got put to the wayside. And so the digital services taxes weren't being addressed at all from a global OECD standpoint. And so it's kind of allowed to wither and decline and just pause there. At the same time, there was a completely different focus on the Pillar 2 piece to look at, instead of how do we make tax competitiveness, look at how do we do subsidize business and operations. And so it really turned into a really bad pivot from that standpoint in terms of what the impact was going to be around the world. And as the material was prepared, a lot of it was done as drafts were coming out. There really wasn't as public awareness of what that shift happened until the final draft came out early 2 years ago, I guess. And at that point in time, it really became apparent that what had been structured was something that was going to be very discriminatory towards the United States. And the businesses working in the United States impact them in terms of the amount of tax they pay, impact them in terms of the amount of processing and how they'd go through the administrative cost to calculate that. And the net effect on the U.S. Treasury was going to be very detrimental through that because of the way the U.S. Treasury's focused on, the way we've looked at in tax codes for a long period of time is how do we come up with, in a lot of cases, non-refundable credits. Basically, the incentive is that you should make a decision that results in income and tax burden for you, and then that decision, whether it's investment in R&D or investment in capital expenditure, is what you deduct off of. Whereas a lot of other countries around the world go into more of a subsidized approach, and how do they incentivize through the subsidies? And obviously that put U.S. companies at a disadvantage because our approach wasn't being included, and theirs was allowed in terms of calculating what would be a minimum tax. So I could go into more details around here. I'm sure you've heard some of them already with some of your panels, and I talked a whole lot around the different conversations around how bad the UTPR piece of Pillar 2 was, and how that would just take away that territorial aspect and the support for having a home-based business and to make it operate and be efficient out of your home country. And so that's where we really got heavily engaged in, this is not the appropriate worldwide process to follow. It throws a lot of decades old of tax treaties on its head, and what we needed to do was go back and let's finalize the Pillar 1 piece so the DSTs are addressed, and do over the process on the UTPRs that were the central piece of the Pillar 2 activity. And so that led, as we were working through the One Big Beautiful Bill, myself and Jason Smith, we had a couple of different pieces of legislation, primarily to look at how do we protect the U.S. tax base if countries were going to go proceed down the route and implement the Pillar 2 process. And he had the chairman's job bill was the Defending American Jobs and Investments Act, which would have had increased withholding tax on international companies. And I had a bill entitled the Unfair Tax Prevention Act, or UTPA. I couldn't think of a word begin with R to make it good, resonating bill to offset that. But basically, it was going to disallow certain credits and have a similar impact on foreign-based companies operating in the United States if they came from a country that was using those discriminatory Pillar 2 pieces on U.S. businesses. And I'll say this, and I think Chairman Smith will say it as well, is we really didn't want a world where we would have to be drafting bills like this to offset bad bills coming from somewhere else. And so that wasn't the best way to do trade. It wasn't the best way to do tax policy. That we should continue down having this hybrid territorial tax process that has been working and will continue to work into the future. And so when the Trump administration came back in, a lot of comments and support from President Trump, from some Secretary Bessent, and a whole host of a crew in the Treasury staff, agreed with this issue, and we're focusing on this was a problem for America and what we should do here. And so, as the One Big Beautiful Bill was being written, we crafted just one small section that combined Jason's and my bill together, and all of a sudden, I think it was like 2 months ago today, that hit the hot button, and it became the hot item going into the final discussions on the infamous Section 899. That became a hot topic out there to talk about. And what it did, I think, was highlighted that one, there is a lot of concern on the part of Congress that we need to make sure that we have good tax code that works for countries across the world, but also through the negotiations that have happened primarily with Treasury, but also with engagement with us in Congress, and how we could move forward. And so the agreement that was brought forth between Treasury and the G7 to actually pull the Section 899 out of the One Big Beautiful Bill as it was sitting in the Senate, with the expectation that the G7 and the OECD countries would also pull back on their Pillar 2 language that they either had already started or they would have started implementing. And that's kind of the best way from a mutual assured destruction process. Doesn't happen. It's the opposite of that. I'm not sure what the opposite of mutual assured destruction is, but good international relations, maybe. That's the right way to say it. I like that approach. I mean, I do think what we have to do and continue forward is continuing, I call it the trust but verify. We took the first step to pull out the 899. Now we got to continue the process, follow through with the G7 and the OECD countries through that. At the same time, need to go and continue to work on the DST issue, because that wasn't resolved and that wasn't as much a part of the agreement as the Pillar 2 piece was. So we've got to continue that work as we move forward there. So I've kind of gone through a lot of different topics going back multiple years on different things, and through this process, we're going to continue to keep focusing on how do we implement and talk about all the things that are in the bill we just passed, the One Big Beautiful Bill, but also going through and like I said, trust but verify that all of the follow-on countries are following through with their provisions to change the tax code, and then also continue the work to get the DST addressed so that there is a global solution for that as well. And I'm looking for that, us getting back into an arena where we actually have a more competitive worldwide economy. And I think that US-based businesses will be successful with that. I think there'll be a lot of foreign-based businesses that will also be successful just because of the way our global economy works. And so I'm looking forward to taxes not slowing down good, successful economic growth. So I don't know if I left time for questions, but I have, I'll just wrap up with that and see if we have. So,
It's about 7 minutes for questions, and we have a mic. Mindy will start.
Mindy has a mic. So thank you for those remarks. I'm going to ask you a question that I often get asked by foreign tax people, and I never have a good answer, so I'm hoping maybe you have a better one. The question I often get asked is, do you see a scenario where the U.S. would ever sign a multilateral tax agreement?
Do I see a situation where the U.S. would ever sign a multi-level tax agreement? Oh.
Not just like a bilateral tax
bilateral
treaty,
tax?
but something like the Pillar 1 envisioned, that was a multilateral tax convention that requires.
So I think there's a possibility of doing that. I think one of the things, and I'll criticize the Biden administration a little bit more than I did earlier, is that they hadn't even included the Democrat members of Congress in some of their discussions. So they tried to get their version of Pillar 2 included in the BBB, the Build Back Better bill that was going on, and there wasn't support in Congress for that. So I think if there's a broader base effort that we could do, it gets a little bit more complicated when you do that, because part of that would qualify as a treaty, which means it's the Senate that authorizes it. But the House Ways and Means Committee is the originator of tax bills. So there's a little bit of ego and jurisdiction that we'd have to have a lot of things line up right to make that happen. Yeah.
Thank you, and thank you for coming today. I appreciate your trust but verify comment, and it resonates with me with respect to the IRS. It's very difficult as tax professionals, I think, to see the IRS reduced in personnel, and then again this week with billions of dollars being cut from its budget. If we're going to raise the revenue we need to raise, I think we have to trust but verify, and the verify part of it is to me being gutted. So how do you think about that?
Yeah, you know, we have the probably largest, most successful volunteer tax payment system in the world, and we've got to keep it that way because I don't want, and I don't think any of us want, a government big enough to force the code that we have written up. So I think what we need to do is make sure that we take the right steps. One of the, speaking as a Republican, one of the Republican pushback on the generic $80 billion that was being added to add IRS agents was sold as it was adding technology, which is sorely needed in a lot of areas. And some agents, more agents are needed too. But it's being sold as one thing and that's not being delivered through that process. So I think that's the resistance as we've talked through from a legislative standpoint. We've got to figure out what that right mix is going forward. You know, we get resistance when Republicans say we should require Social Security numbers for all recipients of tax credits, particularly children, and or who's the taxpayer on the parent income as well. And so you get pushback from the Democrats on requiring those Social Security numbers, versus you get pushed back a little bit on the Democrats or on the Republican side when Democrats say, well, you just need to be creating more endeavors to go out and tax the wealthier. And I think it's that balance that we've got to figure out. How do we continue to invest, and continue to operate, continue to use technology? And I think that's going to save us in a lot of ways to address as the technology becomes cheaper and easier to access. All right. Well, thank you all for letting me come speak. I mean, so this is a subject that obviously I've done a lot with in the last 8 years that I've been in Congress, and obviously it's been a prime time to be here with just all the work that we did with TCJA, and then that led into the One Big Beautiful Bill, and overlay that with all the OECD effort. So there's a lot of things out there that it's been kind of fun to participate in. Sometimes you bang your head against the wall, but I guess that happens everywhere. So thank you all.
Thank you to the Congressman for your remarks. And it's my honor to introduce, as I said before, my former professor, really my first introduction to tax, Michael Gretz, emeritus at Yale Law School and Columbia Law School, right? Oops.
And when I heard about this program, I thought the question of international cooperation versus competition was like a multiple choice exam where the obvious answer was all of the above. National interests will determine which one predominates at any particular moment, I think. The other thing I want to say is that, as the last session made clear, nations are going to compete. And I want to add that zero is not a lower bound. There's no reason to think that zero is the lower bound here. But I want to start at the beginning. In 1918, when to encourage investments abroad, the United States added the foreign tax credit and relinquished its taxing rights to most foreign source income. The U.S. assumed full responsibility for relieving double taxation of its residents and citizens, and as the influential economist Edwin Seligman remarked, the United States is making a present of its revenue to other countries. Over time, the other countries reciprocated with their own foreign tax credits or exemptions for active business income earned by their subsidiaries abroad. What the limitations on that will be in the future is obviously an important question. In 1921, Congress enacted the foreign tax credit limitation and source rules specifying what income is domestic or foreign, a precursor to the arm's length standard and other principles that we still live with. More than a century later, I should add. Soon thereafter, national governments began cooperating over devising international tax rules, and the conflicts at that time were between capital exporting countries and capital importing countries. And the key concepts, including source rules and arm's length pricing, permanent establishment requirements, and non-discrimination principles, had all come into place by 1928 when the League of Nations announced those principles and produced a model treaty that has been the model, essentially, for a whole range, thousands, I understand, of bilateral income tax treaties around the world. A form of cooperation, I should add, that in my view has outlived its time. Then as now, countries' negotiating positions turned on their national interest. And if there was an underlying normative principle, it was to avoid double taxation of cross-border income with the expectation that it would be taxed somewhere once. In January of 1961, President Kennedy called for current taxation of U.S. companies' income from economically advanced countries, as he put it. The Treasury Secretary, Douglas Dillon, described the president's proposals as giving priority to capital export neutrality, which he described as neutrality in the choice between investment here and abroad. That principle over capital import neutrality, which he said permitted foreign income to be taxed at the rates applicable abroad, thereby removing the impact, if any, that tax rate differences have on the competitive position of American companies. In Subpart F of the Code, which emerged a year later, Congress rejected President Kennedy's call for capital export neutrality and instead created a list of certain, quote, abuses compromising between capital import and capital export neutrality. The world then was much simpler. it made little difference in determining corporate residence whether one looked to the place of incorporation, the place of management and control, the location of most jobs and assets, or the residence of the company's shareholders. All gave typically the same answer. The source of income was also less controversial. Sourcing royalty income, for example, to the country where intellectual property is used caused little difficulty, perhaps because nations then were usually either capital exporters or capital importers. Beginning in the 1990s, transportation costs declined substantially, and the technological revolution allowed information and money and some products and services to be moved around the world with a click of a mouse or a telephone call. These changes, along with financial innovations in engineering, prompted national competition and aggressiveness in tax minimization by U.S. multinationals. The emergence of important new economies, especially in Eastern Europe and Asia, the growth and globalization of investment opportunities, and the ability of business entities to amass large pools of capital without going to the public capital markets all contributed. The European treaties also began playing an important role in shaping international tax policy. In the late 1990s, the OECD undertook a project on harmful tax competition. It failed, but it expanded information sharing by authorities around the world. The OECD's Base Erosion and Profit Shifting, or BEPS project that began in 2013 was different from any previous international tax effort because it was blessed and promoted by the prime ministers of the G20. By then, international tax avoidance had moved from the financial pages to the front pages of newspapers and had become a matter of concern to finance ministers, presidents, and prime ministers. An Australian Treasury official told me then that international tax avoidance had become a topic of barbecue conversation. International tax policy then was no longer an obscure, arcane subject controlled by a priesthood of technical experts, and BEPS had to succeed. At least the OECD had to produce a product that allowed it to declare victory. In 2015, as we know, the OECD announced completion of 15 action items that it said were accepted by 140 nations of its inclusive framework. But the BEPS action items stuck close to the existing status quo, trying to modernize but not abandon the provisions and concepts that had been developed a century earlier. The most important omissions included intellectual property. Action 5 endorsed low-rate patent boxes as long as there is a significant nexus of the expenditures producing the IP that qualifies for the patent boxes. As many of you know, I was going to say all, but I'm sure it's not all, Actions 8 to 10 created value creation as elaborated by Dempey, which I will not go through, but Dempey, for intangible assets as the principal fix for deficiencies in source-based taxation. Value creation, of course, was vague and flexible enough to allow the OECD to forge a consensus among the G20 nations. Like value creation, formulary apportionment requires agreement about the appropriate contributors to income and how they should be weighed. These difficulties were exposed in Pillar 1, which was a limited formulary apportionment of income to market countries. It foundered despite claims of multilateral agreement. Common shifts among the states in the United States to single sales-based or overweighted sales-based formulas illustrate the difficulties even in a relatively low-tax environment because of interstate competition for jobs and investment. Although it seems to have reached a dead end, Pillar 1's effort to allocate income to market countries on a formulary basis made clear that the permanent establishment requirement was outmoded, and it exposed the limitations of value creation as a cure-all. For important intercompany transfers of IP, there is no genuine market, and profits among related enterprises are commonly manipulated in a profitable tax planning game. Value creation, in my view, offers little more than an invitation to negotiations over how to split profits. It is hardly surprising that it has failed to provide clear guidance on how IP value is distributed among a multinational company's different entities. I agree with Wolfgang Schoen, who said, "The fuzzy nation of value creation is unhelpful when it comes to developing a coherent concept of international taxation of the digital economy. Knowing how to allocate such income among the nations or entities of creation, production, development, consumption, asset ownership, and deployment, financing, and/or management is inevitably controversial." The underlying pillars of international taxation, I think, as was said earlier, reside on quicksand. Capital export and capital import neutrality can both be fulfilled simultaneously only when capital income is taxed the same in all nations, something that has not happened and never will happen. By 1962, it had become clear that any change can be described as a compromise between import and export neutrality, a license for politicians to do anything. Nevertheless, many people still insist that those concepts are the proper pole stars for governing international tax policy. Nearly 3 decades ago, I urged that we address international tax policy issues by asking what policies will improve the well-being of our citizens and residents. That is the question political representatives ask around the world. The fundamental challenge is that we are still governing today's 21st century, high-tech, innovative, integrated global economy with 20th century international tax concepts. Efforts to update the system make international tax rules, to borrow an image from Sting, like trying to write on the surface of a lake. Before the ink dries, the rules change. So forget about certainty and stability. Pillar 2 endeavored to create comparable minimum taxes throughout the G20 to curtail international income tax planning and international competition for mobile IP. As Treasury Secretary Yellen repeatedly said, Pillar 2 was designed to end the race to the bottom in business income taxes, but as we all know, the Biden administration failed to get Pillar 2 through Congress. The OECD's UTPR extended jurisdictional rules for taxing international income that had previously applied only to countries related vertically to allow taxes on companies related horizontally whenever the entity was part of a larger business that paid less than the 15% minimum tax. Adding fuel to the fire, the OECD refused to endorse GILTI as a qualifying minimum tax. The Trump administration and congressional Republicans responded with a retaliatory tax on entities whose countries provided discriminatory taxes on American companies. I am not a fan of retaliatory taxes on our trading partners. In addition to their potential for reducing direct foreign investment into the United States, adding tit-for-tat income tax retaliations on America's allies to President Trump's tariff actions increased the pressures on Western unity in the face of important challenges from China and Russia. But the retaliation legislation, as Congressman Estes said, served its purpose in promoting the G7 to accept a side-by-side agreement exempting U.S. multinationals from foreign UTPRs and the income inclusion rules, and recognizing that the U.S. minimum tax, formerly known as GILTI, would qualify as an acceptable alternative. In addition to the side-by-side agreement, the OECD will likely soon abandon the requirement that certain incentives, such as for R&D, must be refundable or transferable in order to qualify. The barrier to treating GILTI as a qualifying minimum tax under Pillar 2 was the averaging of taxes paid across nations. And like Julie Rowan earlier, I have never regarded country-by-country limitations as the panacea that many others do. As she put it, opportunities for intercompany blending of low-tax income, such as in patent boxes and through financial hubs, with higher tax income in the same country are simply too great. I am skeptical that the G7 agreement will lead to the demise of minimum taxes around the world, despite German Chancellor Merz's recent call for the EU to suspend Pillar 2 implementation. All countries need the minimum tax revenue, and repealing a 15% minimum tax on multinationals will be costly politically everywhere. The political barriers are going to increase as country-by-country income tax reports become public. Income tax advantages persist for IP income located outside the U.S., despite the 2017 reduction of the U.S. corporate tax rate and the lower FDII, I'm going to still call it FDII, I'm just saying FDII, rate on foreign-derived sales and services, which were enacted to encourage U.S. multinationals to export more goods and services and to locate more intangible assets in the United States. But even if Pillar 2 survives in some form, an ongoing ability to blend high return and low return income will continue to encourage offshore profit shifting. Subpart F, which taxes the foreign source income at the corporate rate, does not normally reach such income. And archaic U.S. and international tax concepts and rules developed a century ago for a very different world economy continue to allow profits that should be considered U.S. income to be characterized as foreign income, not subject to U.S. taxation. The U.S. should reassert its primary taxing rights over income from intellectual property that is created in the United States, rights that it has long surrendered to other countries. Many international tax experts and most of Congress underestimate just how substantially the 2017 and 25 changes, along with multilateral and unilateral developments abroad, have changed how we should be thinking about international tax policy. When the U.S. rate was 35% and U.S. companies could arrange for ownership and deployment of their IP and borrowing so that income would be taxed at lower zero rates, Congress had to allow this even when problems became acute, because the rules that were in place supported U.S. multinationals in their competition with foreign multinationals for the production and marketing of goods and services abroad. Congress naturally wanted U.S. multinationals to win those competitions. But now the international tax context is very different. The post-25 choice for most U.S. multinationals will typically be between U.S. taxation at 21% or 14% under NICTI or FDI, and foreign taxation at a 15% rate, if not more. Even if Pillar 2 collapses, unilateral efforts to collect taxes on income from IP created and developed in the United States, such as we've seen with diverted profits rules and the Australian royalty rules, demonstrate that if the U.S. fails to tax this income, other countries will. A recent NBER article estimates that between 2010 and 2016, profits shifted out of the United States averaged $150 to $200 billion a year, and 38% of the income of U.S. multinationals on their foreign direct investments should have been reattributed to the United States over a longer period of time. There are many culprits in our existing law, such as cost sharing and check-the-box rules. Another is the ongoing ability of U.S. multinationals to locate their borrowing here and interest income abroad. Even more important is the allocation of income from IP to countries where it is used rather than the U.S. when it was created and developed here. As Paul Oosterhuis has detailed, because almost all income from capital in the 1920s was derived from tangible property, source rules for royalties were an afterthought. As he said, royalties from licenses of intellectual property, which are sourced to the country where the intangibles are used or the privilege of use is granted, tagged along with rents, which were sourced based on the location of physical property. In 2020, U.S. corporations received $215 billion of royalties from foreign payers on which they paid $8 billion of U.S. tax, a rate of 3.7%. Likewise, sourcing services where they are performed was originally based on physical location, and income tax treaties often rely on the length of time individual service performers reside there, which is a better general rule. But drawing the line between income from provision of personal services and royalties, from a license of intellectual property, or the transfer of software or the transfer of other intellectual property, produces almost limitless controversy. A half a century ago, in 1975, the U.S. exported $22 billion of services and exported about the same amount. In 2023, we exported only over $1 trillion of services and imported $748 billion. These numbers, of course, include more than personal services, but the increase in all cross-border services has increased dramatically. Congress should retake control of taxation of U.S. income by taxing highly mobile IP and interest income under Subpart F, a change the Congress voted for in 1960, the House voted for in 1962, but was dropped in the Senate, and which was enacted in 1993, but repealed in 1998. Combined with FDII, that would create tax advantages for locating valuable IP in the U.S. rather than abroad. More fundamentally, the U.S. should update its rules for sourcing royalties and other IP income to where the IP is created or developed or where the creator is resident, and provide only routine lender's returns for intercompany funding or any debt financing of IP. Tangible property and personnel abroad that are not involved in research and development, when IP is a predominant contributor to revenue, should also be given only limited markups. R&D deductions and credits could be limited to R&D that produces IP owned in the United States. And the new source rules might apply only to newly created IP with Subpart F applicable to existing IP. Such changes would streamline and in many cases eliminate transfer to pricing disputes over residual profits. And when the delivery of services involves digital content, we might look to on a unitary basis to the residents of the multilateral enterprise that created or developed the IP. If it becomes necessary to cede some income to the countries where IP is used in manufacturing or to market countries, the U.S. could provide a routine markup for manufacturing and distribution and a negotiated return for incremental expenditures on R&D. One might have expected some of these issues to be on Congress's agenda in 1925, including round-tripping of items that have been produced abroad based on IP produced here. But even such sitting ducks were resisted, especially by technology and pharmaceutical companies. The pressure to raise more revenue from multinational companies are only going to grow. The 2025 legislation, as you know, added nearly another $4 trillion over the coming decade to our unsustainable debt and deficits. Our interest payments on the federal debt as a share of the economy are already the highest in the OECD, 6 times higher than Japan's, which has much higher debt as a share of its economy, which is much smaller. China spent less than 1% of its GDP on interest payments last year. The CFRB estimates that more than $1 trillion in interest cost will be added by the 2025 legislation through 2035. Interest costs then, it says, will be 4.6% of GDP and will consume more than a quarter, 27%, of all federal revenues, and they will keep growing. Given our aging population and declining labor participation, we should no longer allow foreign countries to claim taxes on the valuable IP created here. Thank you. I'm supposed to, the congressman is here. I can't allow questions when a congressman is in the room.
District in Illinois. Like me, grew up in the Denver area, but has made his home in greater Chicagoland and has represented the Northern Illinois communities for the better part of a decade. He's a member of the House Ways and Means Committee, member of the Foreign Affairs Committee, and he also serves as chair of the New Democrat Coalition, which is a group of 115 members working across the aisle and across the Capitol to advance economic growth and opportunity, healthy and safe communities, and strong national security and defense. Before that, he had a 3-decade career in the business community. And lastly, and of particular interest to this group, last year he received the National Foreign Trade Council's International Tax Award for bipartisan work to address concerns regarding Treasury's foreign tax credit regulations, which many in this room have opinions about, and for which we are very grateful. Congressman.
Good afternoon. So I know I am last in summarizing what was said, which is always fun to do when you haven't heard what was said. But it is really an honor to be here. And having looked at the agenda and seeing the titles, I think I have a pretty good sense of what was spoken about. I will touch on it. It wasn't my assignment, but we talked about the debt and just kind of your remarks, Professor, and hearing the numbers. Demonstration of I'm a nerd and kind of wonky. We're talking about trillions of dollars. The one big bill added $4 trillion. If you add interest, it's $5 trillion according to CFRB. To put that in perspective, I'm going to use, I apologize not using Denver, but I'll use Chicago framework. If you stack a $1 million bills one on top of the other, it's 358 feet, at least according to Wikipedia. If you turn that on its side, it's a football field, right? From goalpost to goalpost, right? With 2 feet to spare. If you start going from Soldier Field, which is in downtown Chicago, north, dollar by dollar by dollar, does anyone want to guess where you get to $1 billion? It's just over the Wisconsin border between Kenosha and Racine. It's 67 miles. Does anyone want to guess where you go and keep on going to $1 trillion? I hear Canada. It's 2.5 times around the Earth. It's 67,000 miles, right? And so we lose the context of how big the $4 trillion is. I was talking yesterday, or Saturday, we had a town hall, and we were talking about the rescissions package, $9 billion. And said, well, that offsets the one big bad bill. And we went, $9 billion rather, and 4,000 trillion are different numbers. They're different orders of magnitude, and that's the challenge we're facing. So anyway, I will do my best to cover my opening remarks. A little more background on me. I am a nerd and a wonk. I'm on Ways and Means. Technically, we're by contract required. I don't know if Ron said this before me. We're supposed to say the very powerful, very important Ways and Means Committee. It is a wonderful committee, and I'm very lucky to be on that. I have the privilege of being on the Tax and the Trade Subcommittee. What makes me an odd duck on this committee is I think this stuff is interesting. I grew up talking about it. My dad was a CPA, he's passed. But I grew up at the kitchen table talking about tax policy and how it can have an effect. And I understand where it goes and what we can do with it. I'm also, and this makes me even a little more distinct, on the House Foreign Affairs Committee. In fact, I'm the only member on both the Ways and Means and the Foreign Affairs Committee on either side of the aisle, which is somewhat, I think, ironic because one responsible for trade and international tax policy, other than that for foreign policy. Those two things are intrinsically linked and important. As was mentioned, I chair the New Dem Coalition. It's 115 moderates on the Democratic side. That's a majority of our caucus. I will say moderate reflects style more than position. It's how you get things done. The moderates, we roll up our sleeves. People on the extremes tend to promise things that it's going to be easy. I've got the answer. We're going to build castles and clouds, and the castles will be beautiful. Problem is that it's hard to do, and it's hard to keep them there. Moderates tend to roll up our sleeves, work with bricks and mortar, and step by step, and that's what I'm proud. I'm proud to have the chance to lead on that this Congress. So where does that leave me on international tax thoughts? First, a couple of things. The U.S. cannot afford to isolate ourselves from the world. The worst thing we can do is try to go it alone and say, we stand alone. We stand by ourselves. We don't need the rest of the world. And I am very worried about the administration's shift from international agreements, specifically for this purpose, international tax agreements. I'm worried about what it does to our reputation, what it does to our leadership role, our ability to influence policies, and ultimately, our ability to help U.S. companies and the people who work at those U.S. companies succeed in a global economy. I'm concerned, frustrated, and angry about the on-again, off-again tariffs, which are, after all, a tax and which are freezing, not pausing, not delaying, literally freezing and canceling businesses' ability to make both short-term and long-term decisions. I have a company in my district that was prepared to make a $100 million investment in a new facility. They import a lot, they manufacture some, they were in a warehouse here, and they canceled because they just don't know what to do, and they just couldn't make that. It's a family business, not a small family business, a sizable family business, but they can't take that bet not knowing where things are going to be from day to day. I was very concerned about Section 899 in the One Big Bad Bill before it was taken out for negotiations. Think about this for a second. If ever there was an example of cutting your nose to spite your face, 899 is it, right? We had Secretary Bessent in front of the Ways and Means Committee, and I was asking him about this. The United States leads the world on foreign direct investment. We are the magnet. People want to invest in our country. They want to come here and benefit from what we have to offer, from the most productive workers, the best trained scientists and researchers, and it's a real problem. We lead the world in attracting foreign direct investment, and if we're not doing that, if that investment is going somewhere else, it means our economy isn't growing, but other economies are growing at our expense. Why in the world would we penalize companies and individuals who want to bring capital to this country? I was on the Small Business Committee. I used to have a simple, I was asked to speak and I hadn't prepared anything. I could always talk about the 4 things small businesses, middle market businesses need. It's true for big businesses as well. They need a workable business model that's their challenge to come up with. But they need access to talent, access to capital, and a stable political environment. And that we have to work together on. And we need to be able to provide that, and to pull that away. Other places will address that. So I was relieved to see that with the conversations with the G7, in the Senate version it came out, the side-by-side agreement agreed upon in principle still leaves us with a lot of unanswered questions, and depending which direction it goes, it could either be the death knell or leave open progress on Pillar 2, which I'll touch on in a second. But what happens when the rest of the world seeks to work around and without the United States, as we are already seeing Europe do, countries around Asia do? There's a real difference between being a leader of the G7 and being a member of the BRICS. I'd rather make sure we're leading at the G7. And it's not just about our economy. This is a threat to our national security. So let's shift back to taxes. As wildly complicated as international tax policy can be, our work on our committee, that very important, very powerful committee, at the end of the day is very simple. It's ensuring that U.S. companies compete on a level playing field in a global economy that is increasingly integrated. And second, providing U.S. companies incentive to call and stay in the United States as their home, and making sure that the U.S. tax code does not penalize these companies for the work they're doing around the world. Taxes are not what we pay, but it's how we pay for the things that we do. And we pay for 2 things. We pay for the good and welfare of our people, and we pay for the capital investment in our societies, in our communities, the infrastructure, the education, things like that. There are approaches we can take to taxation, and you know that better than I do. We can tax labor income, we can tax capital income, we can tax wealth and inheritance, we can tax a whole list of approaches. How we do it, what we do it, that's where we should be coming together. And that's where we should be working across the aisle, Republicans and Democrats. Because when we work across the aisle, as we did in the last century, and it's hard to believe that the 1990s were the last century, but it was, what compromises were achieved long before I came to Congress were compromises that stood the test of time. What we have seen in the 15 years that I've been in Congress is a pendulum swing. Every time the pendulum swings, everything goes with it, and we're trying to unravel it or reconsider it or revisit it, and it makes it hard. I mentioned the decisions that aren't being made. Businesses don't make 10-year decisions 1 month or 1 year at a time. They make those decisions across time, and they need that stability to be confident that they can make those decisions. And complexity is an enemy of business decision-making, but it's where business decision-making has to live, where it can make a difference. And there's complexity and potential conflict in taxation and tax policy when you start dealing with multiple jurisdictions. This is true at the local level, at the state level, the federal level, and of course at the international level. I'll give you just an example. I live pretty much right on the county line in my district, Cook County and Lake County. You won't be surprised that the road that divides them is known as Lake Cook Road or County Line Road. That makes sense. Okay. But you see clear differences on that seam. Property taxes are higher in Lake County. So the price you pay for a home is less in Lake County because you're going to pay more. It affects the value of that home. But because Cook County has so much mass transit, their gasoline tax per gallon is higher. So if you drive down Lake Cook Road, every single gas station is on the north side or the Lake County side of the road. People make decisions based on tax policy. My district goes up to the Illinois-Wisconsin border. We're constantly fighting to see businesses move from one side of the border to the other. And oftentimes it's close enough that the employees can go back and forth, but the businesses move. Millions of dollars are spent trying to attract businesses to move across that border, but almost zero value is created by that transaction because it's the race to the bottom. And that's what we're seeing in international tax as well. It's just far more complex, all right? In addition, when you get to international tax, companies are going to great pains in that race to the bottom to shift profits. And it's in that process, that's where we've long needed smart international tax policy to maintain US global competitiveness and economic growth. And that was the goal of OECD Pillar 1, Pillar 2, as you all know. The strategic question, what you have spent the day talking about, is competition or cooperation. Okay? Competition is the first instinct. Competition is be the first across the line, to win the prize, to chase the gold medal, or whatever the spoils go to the victor. Okay? And in a zero-sum game, competition is the game. But cooperation, though it's messy up front, is the only way you grow the pie. You get out of the zero-sum. Cooperation, coordination, is the way you lead people on all sides of those jurisdictions better off. If Illinois and Wisconsin would cooperate, we'd do a much better job bringing businesses from outside the United States into these areas to create new jobs, not just shift and move jobs back and forth. So the OECD project was the shared view that cooperation is better than competition, to stop that race to the bottom. And as you know, Pillar 1 was the check on DSTs and enabling profit across jurisdictions or in jurisdictions, not just where those products or services are generated, but where the profits are actually generated as well. And Pillar 2 was to stop that race to the bottom. If we walk away, if we turn our back, if we aren't at the table in those conversations, the world's going to keep on marching. We've been talking about this long enough to see what was surprising isn't so surprising. I'm guessing none of you had South Korea as the first country to take the action and move on changing their tax code. I know I didn't see that. And as we've gone forward, we've seen more countries starting to move without the United States. We have to recognize that cooperation and coordination is in the United States' best interest. And that if we are at the table, if we are consistent in our policies, if we are focused on our objectives, and recognize that it's a level playing field that benefits not just American companies, but will benefit all companies around the world who are willing to play by the rules of fair competition, then we'll be in a much better place, and this is what should guide us. So I'll wrap up with this. There are differences between the Republicans and Democrats in how we view this, and I want to be careful. I only speak for myself. Okay? At the extreme, on one hand, we have the justice warriors and the American, what I call the America alone isolationists. All or nothing, one or the other. Remember, I said moderates. Moderates are style, not position. Between those two extremes, there's a lot of common ground that we can find, and we have to work to find that common ground. The answer is in the middle. We need coordination and cooperation to enable competition in a fair ground. We need to focus on the goals of what we were trying to achieve with Pillar 1 and Pillar 2, recognizing that the first cut may not be perfect, but it gives us a framework to talk about what are we hoping to get to so we can level that playing field and ensure that American companies can compete. And we need to keep talking to craft a solution. Congress has a critical role to play. We need Congress, and now I'm speaking to my colleagues, none of whom are here, but I say this to them as well. Congress has to take back our constitutional prerogatives and responsibilities. We have to stop delegating or abrogating our responsibilities to the executive branch and say this is where it starts. Right? I was joking about the very important, very powerful Ways and Means Committee, but we are the oldest committee. We're the only committee in the Constitution, and we are the committee that is assigned the responsibility to assess and determine what our tariff and trade policy should be. And it's then up to the executive branch to faithfully execute the laws and intentions of the Congress. Right? Problem is, I'm not overly confident about bipartisanship in this current moment. If we're looking forward for the next several months, is there a chance to have a bipartisan solution? And I'll tell you why. You watched earlier this month as Congress finally passed the OB3 or OBBB, OBBBA, whatever you want to call it, right? Here's the thing. The intention was never to find common ground. It was always to create a divide so that there would be no Democrats inclined to support it. Not one of my colleagues had a hard time casting a vote against that because none of us supported the idea of kicking 17 million people off of health care, of taking anti-hunger programs away from our communities, from putting local hospitals at risk, or for adding $4 trillion to our national debt, which is already too big. We need to be going in the other direction. But that's just one piece of it. We need to fund the government by September 30th. Now, you all know, because you're here, how much time we have wasted and how little time is left. September 30th is literally a blink of an eye. I have very low confidence we can get there, though, without Republicans and Democrats coming together. And the reason I worry about that possibility is because of rescissions, or the rescissions bill that passed last week. I said before, $9 billion out of $4 trillion is not a huge number, but it's more the signal that it sent. The signal that no matter what is agreed to, no matter what compromises might be made in trying to achieve or move policy forward that will benefit the entire country, any concessions or compromises that the United States might make, or that the Democrats might make, are going to be washed away later on. How do we trust, as we look at the funding bills for fiscal year 26, how do we trust those compromises will be honored when rescission says, no, we're just going to disregard them? We've got to find a way to make this work. We've got to get over this into a new place. And that's where you all can help. And that's where, as a New Dem, I'm very proud. The New Dems are laser focused on lowering costs, driving economic growth, creating quality, well-paying jobs, and funding our national priorities like robust infrastructure and educating our children for the 21st century global economy. We should all be able to do that together, and when we do that together, when we set priorities and tackle them, not try to do everything all at once, but one at a time, first priorities first, Stephen Covey style, there's nothing we can't do, and that's what we have to focus on together. So I'm getting the signal that I'm done, and I'll take any questions you all might have. Just over here.
Give me the mic. Thank you for a very inspiring speech. I'm going to ask you the same question that I asked Congressman Estes, but I'm going to give you more context than I gave, which is so picking up off your remarks about ways Congress reasserting its privileges in the tax writing process. How did likely, and also from the failure of Pillar 1 to reach any kind of meaningful agreement. So thinking about a lot of what the broader context for our discussion today is really how do we move forward from that failure and what comes next. And so there's, from a process standpoint, one can see either multilateral, another attempt at multilateralism, or something more like bilateral approaches, or unilateral. Maybe the U.S. leads, maybe other countries go in their own direction. So this was a question I asked Congressman Estes. How likely do you see ever the possibility of the U.S. signing or agreeing to ratifying a multilateral tax agreement?
So if you were asking me as President Schneider, the answer would be very likely, but that's just my bias. I believe multilateral gives us good outcomes when we're at the table and leading. I'm not president, I'll never be president. And in the moment we're at, I think we're at the opposite end of that spectrum of likelihood of getting back into multilateral conversations, especially in the context of international tax. It is like that wall of gears where one gear is affecting virtually every other gear. I told you I was nerdy, but just me personally, I see it very difficult to try to get where we need to be on unilateral, bilateral agreements that aren't looking at how everything fits together. And if you aren't bringing, especially at least the largest economies together and getting to a level playing ground and a common understanding, and there has to be give and take in that, it's almost impossible not to see the outliers in that conversation continuing to drive in a way that puts us back in the race to the bottom and hurts everybody else. So the answer is, my answer, as a fan of the Committee for Responsible Budget, as a member of what is affectionately called the BFFs, the Bipartisan Fiscal Forum, we have to do a better job of focusing on these things, having these conversations, and recognizing that the United States needs to be at the table. And it's not just enough to be at the table, we should be leading our ability to innovate, our ability to draw capital, our ability to turn that capital and innovation into productivity and progress that benefits not just our people, but the people around the world. That should give us not just the voice, but the right to help lead that, but we need to do it in a way that affects everyone. So I'm giving you an aspirational answer. I know that, but I really think the only way we can get it done is if it's done multilaterally. I talk to you in a submission or lunch is setting in.
Hi, thank you for coming today. I am interested in education. I'm an intern at the National Education Association, and just America has very low educational outcomes, and we only fund about 8% of our schools from federal taxes. So I was going to ask you about how you balance the Ways and Means Committee focus on American competitiveness with the foreign affairs need to maintain strong economic partnerships.
It's a great question. Let me ask, where are you at school?
I go to the University of Delaware.
Okay. It depends what room I'm in and who I'm talking to, where I feel about this idea that we have good or bad educational outcomes. And what I mean by that, if I'm talking to a room of kids who have had the opportunities and privileges of getting a quality education, I'll put those kids and young people and young adults against anyone around the world, and we're going to win. We know how to educate young people to achieve extraordinary things. And in my district, my most affluent school district happens to be literally right next door to my least affluent school district. And I've been doing this long enough that I've watched some kids grow from kindergarten now on to college and on through high school and into adulthood. And we fail those kids. Not all of them. Some of them are able to rise above the challenges left them or put in front of them and can compete on that global stage, but too many of them are left behind. And this is where I do another one of my numbers games. China and India have 10 times as many people as we have. If they educate 1/10 of their kids at honors level, they will have more honors students than we have students to start with. If we are going to compete on that global stage on the foreign affairs, and it is a global competition for ideas and innovation and growing our economy, we need to be able to make sure that all of our kids are educated to their fullest potential. Federal, as you said, it's a small percent of the total. We can help set aspirational goals. We can help fund the programs like special education and after-school programs and keeping kids in school, working to make that difference. That'd be great. If there was one thing I could do, if I had one wish as a member of Congress, and I would retire tomorrow if I got it, is universal preschool and give every kid that chance to start school and let them go from there. But it is a national security priority, must be. It is an economic priority, and it's a moral imperative to do. So thanks for the question.
Gerald Chandler here. I have a detailed question. You mentioned that businesses need to plan far ahead, and that some of the things we're doing now prevents them from doing that. There are a lot of people who say that, to the contrary, businesses only plan for the next earnings report. Do you agree with that criticism, that businesses typically do that?
So both can be true at the same time, and I have the benefit. I've worked I had a business career before coming to Congress, and I worked for Fortune 500 companies on the inside. I was a business consulting Fortune 100, Fortune 10 companies, and I spent the last more than half of my business career working with mid-market family businesses. What I love about family businesses, we would talk about the agrarian view. They were looking to the long term. They were looking across generations. Publicly traded companies have to look the way it's set up. The incentives to look quarter to quarter. The CEOs and the C-suite have to provide their investors in the markets the quarterly performance, or they're going to be out on their keister. There's two ways to fail as a CEO. One is not make your numbers. The other is go to a Coldplay concert. I just had to say that. Sorry. But it was just there. We put these pressures. So one of the companies I worked with was Sears Catalog. At the end of its life, I had the privilege of being there for the last 2 years. We were brought in from the outside with a longer term contract, but when the new CEO came in, he looked at the quarterly numbers and said, I'm a retail guy, I'm going to get away from catalog. That was 1993. In 1994, Mark Andreessen introduced Netscape, the World Wide Web. Right? Had the leadership been able to be patient, and I would argue also had the vision, Sears had the catalog going to almost every household in America. They had Prodigy, they had distribution centers. Sears already was Amazon before Amazon became what it is today, but they couldn't see it. And the markets weren't giving them that status. Look where Amazon is today and look where Sears is today. So we could do a lot better job of creating and aligning incentives. I wish we could give our large companies the chance to weather storms better.
But that is distinct. All of that has nothing to do with the chaos of tariffs that change hourly, tax policy that changes year to year or even every 5 years. Because when someone invests in a new manufacturing facility, the payback is usually 7 to 10 years. You need to be able to do this to make the numbers work. You need to have a sense of what the taxes are going to be, of what investment incentives might be there down the road. That's the trade-offs, and we have to do a better job of it. Yeah. Okay, I think that was the hook. Thank you.